Bond court is a free service, but it takes several hours of my time every day. Less than 10% of Bond court viewers hit the like button, and less than 1% leave a comment. If you want Bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Good afternoon, sir. State your name and date of birth, please.
Buenos días, caballero, por favor, dígame su nombre y su fecha de nacimiento, por favor.
Gustavo Castellón, 0828 de 1999.
Gustavo Castellón, 082899.
Sir, you've been picked up as a result of operating a motor vehicle without a valid driver's license.
Señor, usted lo detuvieron por conducir un vehículo de motor sin tener licencia de conducir.
The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
El juzgado ha revisado el acta acusatoria y determinamos que existe motivo fundado.
Bond to be set in the amount of $500.
La fianza será programada en $500.
And you are not to drive without a valid driver's license.
No se le permitirá conducir a que no sea que tenga licencia válida de conducir.
Thank you.
Gracias. Okay.
Next case, 22MM705. Benny Leonette Medina.
President approaching, Your Honor.
Good afternoon, ma'am. State your name and date of birth, please.
Buenas tardes, por favor, dígame su nombre y su fecha de nacimiento.
Medina, enero 18 del 93.
Denny Leonette Medina, 18th of January 1993.
Thank you. Ma'am, you've been picked up as a result of battery, simple touch, or strike connected to domestic violence.
Señor, usted ha sido detenida por un cargo de agresión, tocar o golpear relacionado a un acto de violencia doméstica.
The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
Revisamos el acta acusatoria y determinamos que existe suficiente motivo fundado.
You qualify for pretrial release with a bond.
Usted reúne requisitos para el programa de libertad provisional con una fianza.
That bond will be in the amount of $1,000.
La fianza será programada en $1,000.
You are not to return to 3003 Heron Lake Drive, Apartment H.
No se le permitirá regresar al 3003 Heron Lake Drive, apartamento H.
You can go back one time with the assistance of law enforcement to obtain your personal items.
Se le permitirá regresar una sola vez acompañado de un agente del orden público para recopilar sus pertenencias personales.
You're not to have any contact with Caroline Jamin.
No se le permite tener contacto en absoluto con Caroline Jamins.
No contact means no in-person contact.
Eso significa se le prohíbe contacto presencial en persona,
No third-party contact,
contacto mediante una tercera parte.
meaning you're not allowed to have anyone else contact her.
O sea que usted no le puede pedir a ninguna otra persona que la contacte a nombre suyo.
No telephone contact,
No puede tener contacto telefónico.
no social media contact,
No puede tener contacto usando las redes sociales.
no contact whatsoever. Do you understand?
No puede tener contacto en absoluto. ¿Usted entiende? Yes, I understand.
Thank you. You may have a seat.
Gracias por tomar asiento.
Next case, 22CF882, Eduardo Milon Felix.
President approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, caballero. Por favor, dígame su nombre y su fecha de nacimiento.
Eduardo Millán, 13 de diciembre del 84.
Eduardo Millán, 12/13 of 84.
Sir, you've been picked up as a result of allegedly stealing copper from utilities.
Usted ha sido arrestado porque se alega que usted robó cobre de los servicios públicos.
The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
El juzgado ha revisado el acta acusatoria y determinó que es suficiente base fáctica.
It appears you qualify for direct pretrial release. The court will grant it.
Aquí parece que usted reúne requisitos para el programa de libertad provisional y el juzgado lo va a autorizar.
You are to follow all the laws
Usted tiene que cumplir con todas las leyes
and follow all court orders.
y seguir todas las órdenes que emita el tribunal.
Thank you.
Gracias.
And the last one is 22CF883, Asiu Taveras.
President approaching, Your Honor. At this time, defense would be requesting a waiver of the reading of the charges, Your Honor.
Yes,
En
sir.
este momento la defensa pide excusar leer los cargos.
Good afternoon, sir. State your name and date of birth, please.
Buenas tardes, caballero. Por favor, dígame su nombre y su fecha de nacimiento.
Buenas tardes. Alceu Tavares, 8 agosto 5 de 74.
Alcedo Tavares, good afternoon, 8-5 of 74.
Right, court does note this violent offender special concern.
El tribunal reconoce que es un confesor violento de preocupación específica.
Sir, do you know what you were arrested for?
Caballero, ¿usted sabe por qué lo arrestaron a usted? Yes.
Thank you.
Gracias.
The court has reviewed the charging affidavit. I do find there's sufficient probable cause.
El juzgado ha revisado el acta acusatoria y determinamos que existe suficiente motivo fundado.
And bond to be set in the amount of $5,000.
La fianza será programada en $5,000.
You're not to have any contact with the victim, Liani.
No se le permitirá tener contacto con la víctima, Leani.
You're not to have any contact with persons under the age of 18.
No se le permitirá tener contacto con personas menores de 18 años.
You're not to possess or consume any alcohol or drugs.
No se le permite portar o consumir drogas o alcohol.
Do you understand?
¿Usted me entiende? Your Honor, the interpreter did not hear a response from the defendant.
I didn't either. Yes or no? Do you
Sí o
understand?
no?
Your Honor, if we could ask the interpreter to tell him to say it out loud. He just nodded, Your Honor.
Sir, can you respond verbally, please? Yes or no?
Señor, por favor, tiene que responder en voz alta, ¿sí o no?
Me repito otra vez porque no entendí.
Can you repeat that again? I didn't understand.
Did you understand that you're to have no alcohol or drugs?
Que usted entiende que no se le permitirá ingerir drogas o alcohol.
No, yo no uso droga. Alcohol un poquito, no droga.
I don't use drugs and alcohol, just a little bit.
Well, you're not allowed to use any at this time.
En este momento no se le permitirá ingerir ninguna cantidad en absoluto.
You're not allowed to have any alcohol until further order of the courts.
Hasta que se lo indique el tribunal, se le va a prohibir que usted ingiera alcohol.
Do you understand?
¿Usted me entendió? Yes.
Thank you. You may have a seat.
Gracias, puede tomar asiento.
Mr. Barrera, can you make an announcement just in case?
Certainly, Your Honor. Su atención, por favor, si hay alguna otra persona presente que necesite los servicios del intérprete, por favor, alce la mano en este momento.
I see no response, Your Honor.
Thank you, counsel. Thank you, Mr. Barrera. Have a good afternoon.
You
Oops, I cut him off. Gabriel John Colon.
Present and approaching, Your Honor.
Good afternoon. State your name and date of birth, please. Thank you. You've been picked up as a result of a warrant for violation of probation. There's no bond on that. Thank you. Roberto Muniz.
Present and approaching, Your Honor.
Good afternoon, sir. State your name and date of birth, please.
Roberto Munoz, 62586.
Thank you. Mr. Muniz, you've been picked up as a result of an arrest warrant for battery, touch, or strike. The arrest warrant found probable cause. I have reviewed it and I concur. Qualify for pretrial release with a bond. That bond to be set in the amount of $1,000. You're not to return to 4355 Verde Valley Lane in Kissimmee. You can go back one time with the assistance of law enforcement to obtain your personal items. You're not to have any contact with Rosalita Munez. No contact means no in-person contact, no third-party contact, no social media contact, no telephone contact, no contact whatsoever. Do you understand?
Yes.
Thank you. You may have a seat. Below Garlabong.
Your Honor, at this time, defense would also be requesting a waiver of the reading of the charges in this case.
Yes, sir.
He has been provided with a warrant and the arrest affidavit.
Thank you. Good afternoon, sir. State your name and date of birth, please.
Allow Marilyn 5374.
Thank you. Sir, you understand what you've been picked up on for this arrest warrant?
Yes, Marilyn.
All right. Probable cause is found in that arrest warrant. I've read it and I do concur. You do not qualify for pretrial release. Your bond will be set in the amount of $1,000. You're to have only supervised contact with Alexis, and you're to have no hostile contact with Kathleen. Do you understand?
Yes, Your Honor.
State, do you know if DCF case has been opened on this?
No, Your Honor.
All right, if we can just make sure that somebody has followed up with that, the warrant indicates that it might be, but just want to make sure that somebody does follow up.
Yes, Your Honor.
Thank you. Thank you, sir. You may have a seat. Jason Stiver,
President approaching, Your Honor. I believe he has retained private counsel, Your Honor.
sir, can you pull that mask up over your nose?
Yes, ma'am.
Did you retain private counsel?
Yes, ma'am.
Do you want me to wait for them to appear, or do you want me to proceed?
You can proceed.
All right, you've been picked up as a result of a warrant for failure to appear for your arraignment in 21 CF 2807. There's no bond on that, sir.
There's
Thank
no
you.
way I can get a bond, ma'am?
No, sir, not today. Your attorney can file the proper motion. You're killing me with the mood lighting. Robert Carbo,
Present and approaching, Your Honor.
good afternoon, sir. State your name and date of birth, please.
Robert Kyle Harbaugh, June 7th, 1987.
Thank you. Note that this is a violent offender of special concern. Sir, you've been picked up as a result of a warrant for violation of probation. There's no bond on that. Thank you. Andre Van,
Your Honor, after discussing his case with him earlier today, he's requested I waive his appearance.
all right, has been picked up on a warrant for violation of probation. There's no bond on that, counsel.
Yes, Your Honor.
Thank you.
Thank you.
Tyler Bryant,
Present and approaching, Your Honor.
good afternoon, sir. State your name and date of birth, please.
Tyler Bryant, 12/30/95.
Thank you. Mr. Bryant, you've been picked up on a couple of charges. The first is resisting officer, fleeing, and eluding law enforcement when lights and sirens were activated. Reckless driving as a first offense, operating a motorcycle without a license, and failure to register vehicle. The court has reviewed the charging affidavit. I do find that there is probable cause. I do not qualify for pretrial release. Bond to be set on count 1 in the amount of $1,500. Count 2, the amount of $500. Count 3, the amount of $500. Count 4, the amount of $250. You're not to operate any motor vehicles without a valid driver's license, and you're not permitted to operate a motorcycle unless you have the class allowing you to do so. Thank you. Jesus Rebello.
Who did you call for, Your Honor? Sorry, you were, Jesus, Your Honor?
Yes, sir.
He is also, after discussing his case with me, requested that I waive his appearance at this time.
All right, he is picked up on petty theft first offense. Court has reviewed the charging affidavit. I do find there's sufficient probable cause. He does not qualify for pretrial release. Bond will be set in the amount of $500. He's not to return to the Circle K on Simpson Road.
Yes, Your Honor.
Thank you. Michael Rogers.
Present and approaching, Your Honor.
Sir, can you pull that mask up over your nose, please? Thank you. State your name and date of birth.
Michael Rogers, 7/11/79.
Thank you. Sir, you've been picked up as a result of possession of alleged drug without a prescription, as well as possession or use of drug paraphernalia. Court has reviewed the charging affidavit. I do find that there's sufficient probable cause. It appears that you qualify for straight pretrial release. The court will grant that in this particular situation. Conditions of your release are that you are to have not to possess or consume any alcohol or drugs. That includes any prescriptions unless you have a valid prescription for yourself to utilize them, and only in the manner in which they have been prescribed.
Your Honor, pretrial release. Pretrial release did attempt to speak with the defendant earlier this morning, and he refused to speak with pretrial release, so we weren't able to get any information to place him on pretrial release.
All right, Mr. Rogers, do you not want to be on pretrial release?
If they came in the room, I was tired. I didn't even know they came in.
Okay, can you just answer my question, please? Do you want to be on pretrial release, or do you want me to just give you
I
bonds?
don't know what it is. What's pretrial release?
Your Honor, if I may.
Counsel, if you can have a moment to speak with him, please?
Yes, Your Honor.
Thank you.
Your Honor, after explaining both options to my client, he wishes to accept the offer of PTR.
All right, sir, you'll be required to meet with pretrial release. They will be there at the jail, and they will meet with you and go over all the rules and regulations as well as reporting requirements. Additionally, I'm ordering random urinalysis. Thank you. Melinda Goetz?
Present and approaching, Your Honor. Your Honor, if I may, just real quick, on the last one, I was asked to clarify, is that random urinalysis for alcohol and drugs or just drugs, Your Honor?
For both, please.
Yes, Your Honor, thank you.
Thank you. Good afternoon, ma'am. State your name and date of birth, please.
Good afternoon, Melinda Getz, 11/28/1989.
Thank you. Ma'am, you've been picked up as a result of battery, touch, or strike. The court has reviewed the charging affidavit. I do find there's sufficient probable cause. It appears you qualify for pretrial release, but I need to inquire of them further. She lives out of state.
She still will be able to be on pretrial release, because it's only checking in by phone.
Okay. I just wanted to clarify before I went and ordered it.
You're fine.
All right, thank you. All right, so you do qualify for pretrial release with a bond. Your check-ins will be by phone, is what I'm told. Make sure you check in, because if you don't, they will violate you and a warrant will be issued for you. Your bond in this case is going to be in the amount of $1,000. You're not to have any hostile contact with Timothy Bernisky. If you feel you're getting aggravated with him, you need to remove yourself from the situation. Because if you don't, and the police are called, you are the one that will be going to jail. Do you understand? Thank you. Additionally, you're not to have any alcohol or drugs, and there will be random urinalysis for both. Thank you. Counsel, we were supposed to have a recall of a Crystal Richards, but the only paperwork I got on her was from the state. I didn't get any from our clerk.
I did receive, I believe, the same thing from the state, but I do not see her.
I'm sorry, I believe she bonded. I checked. I searched her on our database, and she wasn't in jail, incarcerated anymore.
I will be happy to confirm that if you give me one moment, Your Honor.
I mean, that would be great, because I didn't make a ruling on charge 1. I made a ruling on charge 2, which is why it was rolled till today.
Yes, Your Honor.
So if we can inquire, please.
Yes, Your Honor, just give me one moment.
Thank you.
Case, Judge, I can put a order here.
Here you go.
Bond court is a free service, but it takes several hours of my time every day. Less than 10% of bond court viewers hit the like button, and less than 1% leave a comment. If you want bond court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.
Judge Knight's presiding on the first appearance calendar. Today, it's an informative calendar. I'm here to tell you what you're charged with, what your bond amount will be if you're entitled to bond, any special conditions of bond, your next court date, which is your preliminary hearing date. Also, I'm going to appoint an attorney to represent you if you qualify, or if you wish to have a court-appointed counsel based on the application for court-appointed counsel that you completed this morning. But most importantly, before I do all of that, I must inform you of your United States constitutional rights. These rights never go away. No one will take them away from you. You are the only person who can voluntarily waive those rights if you choose to do so. You have the right for the state to prove this charge or these charges against you beyond a reasonable doubt. That is the state's burden of proof. The state is the district attorney if you're charged with a felony, or the solicitor general if you're charged with a misdemeanor. The state are also inclusive of people who are known as state actors. Those are, for example, the police, sheriff, an investigator, a drug tester. Anyone involved with the prosecution of your case is considered the state. So the state has the burden, and the state alone. You have no burden. You have the right to a speedy and public trial by jury. You have the right to see, hear, and cross-examine any witnesses that the state may call to testify against you. And of course, you have the right to subpoena witnesses on your own behalf and to testify if you choose to do so. If you do not choose to testify, no presumption of your guilt may be raised. And most importantly, you have the right to an attorney. So you have the right to counsel to represent you in every proceeding related to this charge or these charges. I must let you know I'm not your attorney. I'm not here to assist you. I can't give you legal advice. That's not my role. The best person to speak to will be your lawyer. Also, this is being live streamed on YouTube, so someone can be watching it right now. Also, anyone could watch it later, so the state can review your first appearance. So resist the urge to tell me facts about your case. If you say something and later regret it, that will be on you. All right, so what I must let you know today is that I don't work with the state, the public defender, the bonding company, or the sheriff. So I have no idea what your bond fees will be or your percentage. The best person for that will be a representative from the bonding company. I can only tell you what the total amount is, and the bonding company will go from there and direct you as to what specific needs to be paid for you to be released. Unfortunately, some of you will not today. If you're charged with what are known as the 7 deadly sins or 7 deadly crimes, you can't get a bond. Murder, child molestation, rape, armed robbery. You're not getting a bond on those charges. You're not getting one today, not from me. You must be in front of a superior court judge at a later date, a bond hearing date. And that bond hearing date is coming up on May 10th. You can get a bond before then if you speak with your lawyer and your lawyer speaks with the district attorney and work on getting you a bond before that date. There can be other conditions that determine your bond. For example, other charges like trafficking, any drug, or your criminal history, or other factors that I've reviewed to date. So speak with your lawyer, and your lawyer can get you a bond on a different day. Also, your next court date, well, let me go back on bond for a moment here. Some of you will have special conditions of bond. Special condition means you go somewhere or you can't contact someone. So if I say don't go to 123 Main Street, can't go there. Don't contact Joe Smith, you can't contact that person. Failure to comply with special conditions of bond can result in additional criminal charges, such as influencing a witness, aggravated stalking, and other charges, criminal trespass, other charges. So you're now on notice. When I first appear you and speak with you individually, if you don't tell me you don't understand the special condition, then it's presumed that you understand. And also on your bond order, you may have that before you leave and get a copy before you leave the jail, and get a copy when you bond out. So you're on notice. So you can't say, I didn't know, I can't cook that place. No, I can't contact that person. You're on notice right now. And when I speak with you individually, the only way that you will not be on notice is if you tell me you don't understand and I explain it to you again until you do. Also, your next court date is your preliminary hearing date. Your preliminary hearing is also known as a probable cause hearing. Some people call it a prelim. Your probable cause hearing is where the state must present a witness or witnesses, and they must explain why you were arrested. It has to be a lawful, valid arrest. They have to say it. They have to articulate, I arrested this person because, and outline the violation of the law. If it's a valid, lawful arrest, then your case will be bound over to state court for misdemeanors, superior court if you have at least one felony. If it was an illegal or unlawful arrest, then your charge or charges may be dismissed. Your preliminary hearing, if you're charged with a felony, May 9th, charged with a misdemeanor, May 10th. These dates are all at 8:30 a.m. Also, once I go over these matters with you individually, I'll give you a chance to ask questions at the end. Please allow me to outline to you what you're charged with, your bond, if you're entitled to bond. special condition if there are any. Also, tell you you'll hear the same 9th or the 10th of May. The bond hearing is the May 13th. And I will appoint an attorney if you qualify or if you wish to, if you noted that you want one. And that will conclude your first appearance. If you have any questions only related to those 5 things, I can answer those. Be the end today. All right, each of you raise your right hand. Each of you solemnly swear or affirm any statements or testimony you may give in this matter not pending before the court shall be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, gentlemen, be on standby. We'll have the ladies first.
Step on up, ma'am. Introduce yourself.
Good morning, Your Honor. My name is Asia Baker.
All right, good morning, Ms. Baker. You're charged with 1 count of driving under the influence of alcohol, less safe. Your bond is $5,000. Hit and run, $500, and open container, $500. Your preliminary hearing is the 10th of May, 8:30. And Ms. Baker, I am appointing an attorney to represent you. Do you have any questions?
Can you repeat the bonding, please, so I can?
6,000 is your total.
6,000. That was for all 3 charges, correct?
Yes, ma'am.
Okay.
All right. Do you have any other questions?
No, sir.
All right. All right. Thank you.
Thank you.
Brown.
Good morning.
All right. Good morning. All right. Ms. Brown, good morning to you. You're charged with 1 count of battery, family violence. Your bond is $3,000. There's no contact at this time with Robert Brown, and your preliminary hearing is scheduled for the 10th of May, 8:30. I am appointing an attorney to represent you. You have any questions, Ms. Brown?
No, sir.
All right. Thank you.
Thank you.
Amy Kent.
All right. Good morning to you, Ms. Kent. You're charged with 1 count of driving while license suspended. Your bond is $1,500. Tag or no tag is $500. Violation of the Georgia Controlled Substances Act, that is possession of Schedule 2, $8,000. Possession of a drug-related object is $500. And possession of a firearm during the commission of a felony is $5,000. All right, $15,500 is your total. Your preliminary hearing is scheduled for the 9th of May, and that is at 8:30. And 1 moment here, Ms. Kent. All right, I am appointing an attorney to represent you. Do you have any questions?
No, sir.
All right, thank you.
Matthews.
Good morning, Your Honor. My name is Albert Matthews.
All right, good morning to you, Miss Matthews. You're charged with one count of refund by fraud. It's a misdemeanor. Your bond is $3,000. One count of identity fraud is misdemeanor, $3,000. 2 counts of violation of the Georgia Controlled Substances Act, possession of MDMA, ecstasy, and possession of Schedule 2. It's $8,000 on each of those 2. All right, $22,000 is your total. Your preliminary hearings are made. That's at 8:30. And lastly here, Ms. Matthews,
You said May what?
I'm going to appoint an attorney to represent you. Do you have any questions?
No, sir.
All right.
May 8th. Your Honor, did you say what date? May what?
May 9th is your preliminary hearing.
Okay, thank you.
Yes, ma'am.
Thank you.
Lativa Riley.
Good morning, Your Honor. Lativa Riley.
All right, good morning to you, Ms. Riley. You're charged with 1 count of theft by taking. It's a misdemeanor. Your bond is $2,000. Preliminary hearing is the 10th of May at 8:30. And I am appointing an attorney to represent you. Do you have any questions?
I was told that the lieutenants could request an OR bond because I do have 2 small children outside of here that don't have anybody with them right now, and I do need to get back to them. And this is my first offense.
Yes, ma'am. Your bond is $2,000. All right, you have any other questions?
You said May 10th?
Yes, ma'am.
Alrighty, thank you.
Yes, ma'am.
Brittany Sanchez.
Good morning, Your Honor. My name is Brittany Sanchez.
All right, good morning to you, Ms. Sanchez. You're charged with 1 count of criminal trespass. It's a misdemeanor. At this time, there's no contact with Jonas Lawrence. Preliminary hearing is the 10th of May. That's at 8:30. And Ms. Sanchez, I am appointing an attorney to represent you. Do you have any questions?
So it's no bond, correct?
2,500.
Okay, thank you.
Yes, ma'am.
Have a good morning.
You too.
Thanks.
Good morning, Your Honor. I'm Paige Thomas.
All right, good morning to you, Ms. Thomas. You're charged with 1 count of criminal trespass. It's a misdemeanor. Your bond is $2,500. Your preliminary hearing is the 10th of May at 8:30. And I am appointing an attorney to represent you. Also, there's a special condition of your bond: no contact with Tyrese Williams. Do you have any questions?
No, sir.
All right, thank you.
Thank you.
All right, Deputy Bush.
That will conclude it.
Yes, sir. We'll see you next time. Thanks for your help this morning.
See you next time, sir.
We'll see you. All right, good morning to you, sir. What's your name?
I'm the carrier's badge on.
All right, Mr. Bass, you're charged with 1 count of theft by receiving stolen property. It's a misdemeanor. Your bond is $2,000. Your preliminary hearing scheduled for the 10th of May. That's at 8:30. And you're hiring your own. Is that correct?
Yes, sir.
All right. You have any questions?
No, sir.
All right. Thank you.
Thank you.
All right. What's your name?
Joey Calhoun.
All right, Mr. Calhoun. Good morning to you, sir. You're charged with 1 count of theft by receiving stolen property. It's a misdemeanor. Your bond is $2,000. Your preliminary hearing is scheduled for the 10th of May. That is at 8:30. And lastly here, Mr. Calhoun, let's see. You're hiring your own attorney?
Yes, sir, I am.
All right. You have any questions?
No, sir.
All right. Thank you.
Hey, how's it going?
Yes, sir. Mr. Cofield, how you doing today?
I'm doing okay. How's it going?
All right. It's going pretty good here. All right. Let's see. Charged with 2 counts. One is battery and the other is simple battery. On the battery, your bond is $5,000. Simple battery, $2,500. No contact with Nurse Gina Parker and Michelle Patterson. You can't return to the 1 Upper Riverdale Road address at this time. If you must return there, you must make an appointment with the Clayton County Sheriff or the police to accompany you to go to that residence to get any of your belongings. You must do so within 10 days of your release. So I am appointing an attorney to represent you. Do you have any questions?
No, that's it.
All right.
Thanks a lot.
All right. Thank you.
Right. Wait. One question. Just if I need to go back there, just contact the police. And if
Yeah, you have to do it within 10 days of your release. So once you bond out, you can start making contact to schedule for them to go with.
Okay, thanks. And if I need to go to the hospital or anything, just contact the police as well, and they'll help me to get to the hospital where. Oh, okay. So if I need to go to the hospital or anything, which is the same address, if I need to go to that hospital, just contact the police as well and help me out.
Yes, sir.
Okay, just making sure I got it. Okay.
Good morning, Your Honor.
Sir, is this David Craig?
Yes.
All right, sir. You're charged with 1 count of criminal trespass. It's a misdemeanor. Your bond is $2,500. You can't return to the Hartsfield-Jackson International Airport at this time unless you have a valid plane ticket or a MARTA ticket. Your preliminary hearing is the 10th of May, and that is at 8:30. And I am appointing an attorney to represent you.
All
Do
right.
you have any questions?
Yeah. I'm asking that I'll be released on my own recognizance, and I'm asking that my hearing date be this month, like in April, because I'm a victim of a political hate crime. I'm a victim, and it's at the airport, and I was assaulted 2 times by the airport people. And it's a FBI investigation. I'm a witness, and I'm a victim at the airport, and that's where all the people who assaulted me come through, and they know that. And that's why I'm supposed to be in court That's why the trespassing, they put me in Atlanta. They put me over here because they said I wouldn't get out soon. That's why I'm here.
All right, Mr. Craig, your bond is 2,500. You can't go to the unless you have a valid MARTA ticket or a plane ticket. All these other things that you're trying to tell me, you need to tell your lawyer, okay?
All right, when are they gonna come see me?
I have no idea, sir. I don't work with them.
All right, because I'm going back.
How you doing, Your Honor?
Yes, sir. I'm good. How you doing?
I'm doing okay.
Who's this, Nicholas Culp?
Yes, sir.
All right, so you're charged with 1 count of terroristic threats and acts. Your bond is 10,000. There's no contact with Corshana Perry. Your preliminary hearing scheduled for the 9th of May. That's at 8:30. And you're hiring your own lawyer?
Yes, sir.
All right, you have any questions?
I have one question. Who is? Can you tell me who that is? I don't even know who that is.
All right.
I'm truly and honestly unaware of the
All right.
crime, so I don't really.
The warrant reads that on December 19th, 2021 at 5631 West Fayetteville Road, Atlanta, the accused did commit the offense of terroristic threats in that he did knowingly and willfully threaten to commit the crime of violence against the person of Miss Corshana Perry with the purpose of terrorizing Miss Perry by threatening to kill Miss Corshana Perry in the presence of Miss Summer Banks. Mr. Nicholas Culp stated, "I'll die for this shit. I'll put a bullet in you. I'll kill you," towards Miss Perry. That's what the warrant reads, sir.
Hey, I don't know them, but I can't wait to go to court. Thank you, sir.
Yes, sir. Thank you. All right. Deputy Ricania said Dulaney is out on bond.
He stepped out, sir.
All right. Thank you. What's your name?
Emmanuel Ely.
All right, Mr. Ely. Sir, you're charged with 1 count of theft by deception. It's a felony. Your bond is 10,000. 1 count of identity fraud. Your bond is 5,000. Can't return to U-Haul at this time. Preliminary hearing scheduled for the 9th of May. That's at 8:30. You're hiring your own lawyer?
Yes, sir.
All right. You have any questions?
No, sir.
All right. Thank you, sir.
Thank you.
Yes, sir.
All right. Yes, sir. Good morning. What's your name?
My name is Sartarius Darnell Hope, but my brother used my name, so I'm up under his name, Anthony Gates, Anthony DeAndre Gates.
All right, Mr. Gates, you're charged with 1 count of battery, family violence. Your bond is 5,000. 1 count of criminal trespass, 2,500. There's no contact with Renee Kelly. You can't return to 5738 Old Dixie Road in Forest Park. If you must go there, you must contact the Clayton County Sheriff or the police or the Forest Park Police, and they will accompany you to that address to get any belongings. You must do so within 10 days of your release. And I am appointing an attorney to represent you. Do you have any questions?
Yes, but that's not me. That's my little brother and his baby mama. My little brother uses my name. My name is Sartarius Darnell Hope.
That's you gotta talk to your lawyer about that. I can't do anything about that right now.
Okay, could you tell me? Could you tell me when he assaulted her? What date? What happened? It happened.
This was July 6, 2021 at 5738 Old Dixie Road, Forest Park. Defendant did intentionally harm and cause visible injuries to the victim, Renee Kelly. by punching her repeatedly in the face, including the side of her head and mouth. Said victim had a small knot on the left side of her face, near her ear, as well as on her cheek on her right side. Said victim also had a bruise on the inside of her lip. Said victim and the offender shared 2 children and was living together previously.
And that's not me, man.
All right.
And that's not
All right,
me.
you got to sort that out. All right, that's for a different day and for a different court appearance, not today.
Okay, what the bond was now? 5,000, 2,500.
Yes, sir.
All right, yeah, man.
How you doing, y'all?
Yes, sir, Mr. Glover. How you doing today?
Doing well. Could be better.
All right, I understand the situation. So you're charged with 2 counts of simple family violence, 2,500 on each of those 2. They're misdemeanors. 1 count of cruelty to children in the 3rd degree. 2,000 is your bond. No contact with Inshira Curtis at this time. Preliminary hearing scheduled for the 10th of May, 8:30. And I am appointing an attorney to represent you.
And the total, sorry.
The total bond, 7,000. All right. You have any questions?
Is Rukia on there? There's no contact?
What'd you hear me say?
Just the one person.
All right.
All right, have a good day.
Yes, sir.
Harris.
How you doing, sir? What's your name?
William Harris.
All right, Mr. Harris, you know what you're charged with?
Yes, sir.
All right, there's no bond on any of your offenses today.
All right.
Your preliminary hearing is the 9th of May. That's at 8:30. Your bond hearing is the 13th of May, 8:30. And I am appointing an attorney to represent you, sir. Do you have any questions?
No, sir.
All right, thank you.
Yes, sir.
How you doing, Your Honor?
Yes, sir. Good morning. How you doing today?
I'm fine, sir.
All right. Is this Orenthal Hollis?
Yes, sir.
All right. You're charged with 1 count of stalking. It's a misdemeanor. Your bond is 5,000. You can't have any contact with Zanzi Green.
Yes, sir.
You can't return to 8255 Freestone Drive in Jonesboro.
Yes,
Your
sir.
preliminary hearing is the 9th of May, 8:30. And you're hiring your own lawyer?
Yes, sir. I thought that paper said the 10th.
You have any questions?
I thought the paper
You're
said
right. It is the 10th. You're right. It's the 10th.
Thank you, sir.
All right.
All right.
You have any questions?
No, sir.
All right. All right. Thank you.
Thank you.
Jackson.
Yes, sir. Hello, Judge.
How you doing, sir? What's your name?
James Jackson.
All right, Mr. Jackson. You're charged with 1 count of financial transaction card theft. It's a felony. Your bond is 5,000. Then you're charged with violation of the Georgia Controlled Substances Act. Felony. It's 8,000. Your preliminary hearing scheduled for the 9th of May. That's at 8:30. And I am appointing an attorney to represent you. You have any questions?
Yes. No.
All right. All right, sir. Thank you.
Thank you.
Mr. King. No, sir. We'll go to the green hats.
Yes, sir. Charles Anthony Keene.
Yes, sir. Good morning. How you doing?
Good morning to you. I'm doing good here. How about you?
Could be better, Your Honor.
Yes, sir. I understand. All right, Mr. Keene. You're charged with 1 count of Criminal trespass, it's a misdemeanor. 2,000 is your bond.
That be all?
This is your sister?
I believe so.
All right. You all live together?
Yes.
All right, it's $2,000 bond. Your preliminary hearing is scheduled for the 10th of May, 8:30.
Yes, sir.
All right, thank you.
Thank you.
Penn Street, TJ.
How you doing, Your Honor?
Yes, sir, how you doing? Mr. Minstry?
Yes, sir.
Or, I'm sorry, McKinstry. Say it for me.
McKinstry. TJ
McKinstry.
Yeah, yes, sir.
Yes, sir. All right, so one count of theft by receiving stolen property is your charge. It's a felony. Your bond is 3,000. You can't go back to Truist Bank.
Okay.
Preliminary hearing is the 9th of May, 8:30.
Thank you, sir.
And I am appointing an attorney to represent you.
Okay. Thank
Yes,
you,
sir. You're welcome.
Have a blessed day.
You too.
Ellie. Ellie. Just 1 second, Your Honor.
All right.
Yes, go on up.
What are you doing there, sir?
Yes, sir. How you doing, Mr. Miller?
Morning.
All right. Charge of one count of theft of lost or misladen property. Your bond is 2,000. Preliminary hearing is the 10th of May, 8:30. You have any questions?
Is there any way I can get like reduce, be able to signature bond or anything like that?
Did you know the bond before you came up this morning?
They told me that when I came in last night.
Yes, sir. So you knew last night. So that bond was preset. Okay. So I'm not going to change it because it was already preset. Okay.
So how am I supposed to be able to make bonds, sir?
I don't know the answer to that, sir.
Thank you.
Yes, sir.
Next.
How you doing, sir?
How you doing?
I'm fine.
All right. What's your name?
Shamari Mitchell.
All right, Mr. Mitchell. You're charged with one count of driving under influence of alcohol less safe. Your bond is 5,000. Obstructing an officer, misdemeanor. Your bond is 1,000. Possession of marijuana less than 1,500. Red light violation, 1,000. Open container, 500.
Okay, how much is the whole bond?
9,000 is your total.
All right, thank you.
You're welcome. Your preliminary hearings, oh, okay. One moment. The 10th of May, 8:30. And I am appointing an attorney to represent you. Have any questions?
No, Your Honor.
Yes, sir.
Can I ask a question? One question.
Go ahead. Go ahead.
Can I get like a bond reduction? Because I can't afford it. I'm on Social Security.
I understand the situation, sir. That's your bond.
Okay.
All right.
All right, thank you.
You're welcome.
More. Darnell Moore. Or. Yeah. We have Darnell Sane, Junior Moore. Or is more. You don't know more? No, that's not him. No, Walker.
Yes, sir. Darnell Sean Moore Jr.
No, sir. Jamal Portis.
Jamal Portis. All right, Mr. Portis. You're charged with one count of headlight violations, 500. Giving a false name, date of birth or address, 1,000. Driving unlicensed, 1,000. preliminary hearing, the 10th of May, 8:30.
Commissioner, ask a question.
All right, make sure here. Yes, sir, go ahead.
Sir, I'm a manager at McDonald's and I got to get out so I won't lose my job. Is it possible I can get a signature bond? Or some type of serious probation, sir? Like I can't lose my job. I can't make that bond.
All right, one moment. Well, you know that you knew about the two of the bonds before you saw me, right?
Yes, sir.
All right. So you already have 1,500. So I'm going to reduce the giving a false name. That's going to be 500 instead of 1,000. Okay. So your total bond is now 2,000.
2,000.
Yes, sir. That's your total.
Thank you.
Yes, sir. You have any other questions? Nope. All right.
Triple agreement record. Jalen.
Yeah, how you doing, sir?
Yes, sir. How you doing? What's your name?
Jalen Riker.
All right, Mr. Riker. You're charged with one count of driving while license suspended. 1,500 is your bond, and no insurance is 1,000. Your preliminary hearing scheduled for the 10th of May. That's at 8:30. And let's see here, Mr. Riker. All right. You have any questions?
Is it possible I could do a signature bond on that, or is that set in stone, sir?
No, sir. That was preset. So
Okay.
I'm not changing those.
What's the total, sir, again?
Your total bond is 2,500.
Okay, thank you, sir.
Yes, sir.
Monte Walker.
Yes, sir. What's your name? All right. So you're charged with one count of theft by taking 2,000 as your bond. Criminal trespass, 2,500. Simple battery, 2,500. And robbery.
Robbery?
You're Devontae Walker, sir?
I mean, they didn't even tell me these things happen what happened, sir.
Are you Devontae Walker?
Yes, sir.
All right. There's no bond on the robbery charge. That's a felony. Your preliminary hearing is set for the 9th of May. That's at 8:30. I am appointing an attorney to represent you. Your bond hearing is the 13th of May at 8:30. You have any questions, sir?
No.
All right. Deputy Ricania?
Yes, Your Honor.
All right. I was just making sure that Mr. Walker was okay.
Yes, sir.
All right. Thank you.
Reginald Walker. Good morning, Your Honor.
Good morning to you. Is this Reginald Walker?
Yes, sir.
All right, so you're charged with one count of theft by conversion. It's a misdemeanor. 2,000 is your bond.
Yes, sir.
The 10th of May, 8:30 is your preliminary hearing.
Yes, sir.
And then lastly here, Mr. Walker, I am appointing an attorney to represent you. Do you have any questions?
No, sir.
All right, thank you.
$2,000. Yes, sir. Thanks, sir.
Yes, sir. Thank you.
Eric Marshall Williams.
All right, before we do the fugitives,
We have two.
no, he's not a fugitive. Oh,
We
we
have
got,
two
okay,
people.
he's not the fugitive. I'm sorry, I mixed him up. All right, how you doing, sir? Is this Eric Williams?
Yes, sir.
All right, so you're charged with 1 count of theft by receiving stolen property. Your bond is 10,000 on that offense. Possession of less than an ounce of marijuana is 1,500. Identity fraud, 3,000. Refund by fraud, 3,000. Driving while license suspended, 1,500. Preliminary hearing is the 9th of May, and that's at 8:30. And I am appointing an attorney to represent you. You have any questions? All right, thank you.
Wilson. Curtis Wilson.
All right, Mr. Wilson, good morning to you, sir.
Good morning, sir.
All right, you charge of 1 count of financial transaction card theft. It's a felony. Your bond is 4,000. Your preliminary hearing is the 9th of May. That's at 8:30. And I am appointing an attorney to represent you. You have any questions, Mr. Wilson?
Yes, is it possible I can get a reduced to a signature bond? 'Cause this is my first time ever being charged with this, and the officer that arrested me, I had informed him that I had just found the card, and I called the number on the back of the card just to see, to let them know, to try to get a hold of the person whoever lost it. That's how I got charged with this, because I never used the card, and the officer said just because I called the number on the back of it is the reason why he's charging me with it.
You need to tell that to your lawyer, sir. 4,000 is your bond.
Okay, thank you.
Young. Reach Young. Oh, really, what's up? Go back to your room 116.
Good morning.
Good morning to you, sir. What's your name?
Young, Tracy.
All right. Sir, you're charged with 1 count of simple battery. It's a misdemeanor. Your bond is 2,500. Then you're charged with 1 count of giving a false name, date of birth, or address. Misdemeanor, 1,000. Preliminary hearing is the 10th of May at 8:30. There's no contact with Felipe Rodriguez. Do you live there at the 852 Bryan Lane, Forest Park address?
I did.
All right, you no longer live there?
No.
All right, no contact with Felipe Rodriguez. Lastly, I am appointing an attorney to represent you. You have any questions?
Thank you.
Yes, sir, thank you.
Zimmerman.
Yes, sir. What's your name?
Person Zimmerman.
All right, Mr. Zimmerman, you're charged with 1 count of possession of controlled 2 or possession of a Schedule 2 controlled substance, MDMA. It's a felony. Your bond is 8,000. Preliminary hearing is the 9th of May. That's at 8:30. You have any questions, sir?
Yes, sir. Is it possible I can get a signature bond?
No, sir, that's not possible today.
Okay. Thank you.
Yes, sir.
Your Honor, if we can we bring the fugitives up and then have Mr. Moore last? We're bringing him down as we speak.
All right, sure, that's fine.
Y'all come up. Moore, not Moore. Williams. Hussein. Yeah, y'all come up.
Yes, sir, what's your name?
Eric S. Williams.
All right, let's share the spotlight with Richardson. How you doing, Mr. Richardson and Mr. Williams?
Okay, all right.
All right, I'm going to speak to both of you at the same time, okay? So, and then I'll address you individually once I talk about your specific reasons for being here. So what's happening today is that you're here for the beginning phases of an extradition hearing. And so you're here because there are warrants that outline specific things for you, Mr. Eric Williams. The warrant reads that you did enter and remain in the state of Georgia, knowing you are wanted by Alabama Department of Corrections for parole violation, and the state of Alabama will extradite Mr. Mark Richardson. You're here because your warrant reads that you did enter and remain in the state of Georgia, knowing that you are wanted out of Henrico County Police Department in Virginia for multiple counts of fraud, illegal use of credit cards, a felony. They will extradite. So each of you gentlemen are here for me to inform you of what can happen next. So you're here under the official code of Georgia, or OCGA, Title 17, Chapter 13, and that states that you will be held here in the Clayton County Jail for up to 90 days. I will not give you a bond because you're considered a fugitive. And so a seal can be prepared under, or a warrant can be prepared under the seal of Georgia's Governor Brian Kemp, while you wait for your formal extradition hearing. And you can, at that extradition hearing, contest 4 things. First, you can contest whether the documents on its face are correct. So that means like the warrant I just read to you and any other documents that may be produced, whether they're correct and accurate on its face. You can contest whether you are in fact Eric Williams or Mark Richardson. You can contest if you're that person or not. You can contest whether the crime that you're charged with in Alabama or Virginia are indeed still crimes in those respective states. And lastly, you can contest if you are in fact a fugitive or not. Those are the only 4 things you could contest, not your guilt or innocence. That would be for Alabama, for you, Mr. Williams, or Virginia for you, Mr. Richardson. So those are the only 4 things you can contest here in Georgia. If you choose to waive the formal proceeding, however, you will remain in the jail there in Clayton County for 10 days. And the state of Alabama or the state of Virginia will have that time period to pick you up or make arrangements to transport you. And you will deal with the charges there. Keep in mind, they can ask for an extension, but generally it's 10 days is the time period. So this time, Mr. Williams and Mr. Richardson, I must ask you, what is your preference? Do you wish to waive your the formal extradition proceedings, or do you wish to contest or fight it here in Georgia?
I don't, I'll let them extradite me, Your Honor.
All right. All right. So, Mr. Williams, you will sign off on the extradition documents, the papers there, and that will complete your appearance here, sir, unless you have any other questions.
So when they sign the papers, they still got 90 days to come get me?
No, it's 10 days because you'll be waiving.
Okay. And one more thing, like my warrant, Your Honor, I just seen my parole officer last week and she didn't notify me that I had a warrant or none of that. So I wish I could just bond out and return myself to her, because I see my parole officer faithfully. I pay all my money, but I just seen her last week and she said she didn't tell me I had no warrant. Why she didn't lock me up?
Yes, sir. Well, we can deal with that in Alabama, sir.
Okay.
All right. You have any other questions?
No, sir.
All right. All right. What about you, Mr. Richardson?
Yeah, I'll go ahead and waive. I'm in the same boat. I was on a plane going out of the country. I had no idea I had a warrant at all. You know, I would have had my lawyer connect with Henrico County to get it taken care of, but I just didn't know.
Yes, sir. Well, I understand. So you can go ahead and sign off on the waiver documents as well, and certainly hope things work out for you there in Virginia.
All right.
Yes, sir. Thank you.
And Your Honor, Mr. Moore is still en route. He's on his way now.
All right. Let's see. Moore, Darnell Moore. All right. Oh yeah, I was asking. I think you had stepped off. There was someone who bonded out. I'm trying to. Let me flip back through here. Someone bonded.
The last name starts with a D. One who bonded out, that was it's Kyrell. Lune, that person bonded out.
Okay.
Again, we're still waiting on Mr. Moore. Again, he's on his way right now. Deputy Bush is bringing him.
All right. Yeah, I'll be on standby for when he gets here. I'll just turn my camera off, do some paperwork here.
Thank you, Your Honor.
All right, no problem. Thank you. All right, how you doing, Mr. Moore?
Best I can right about now.
Yes, sir, I get it. So you're charged with 1 count of driving under the influence of alcohol, less safe. It's a misdemeanor. Your bond is $5,000. And your preliminary hearing is the 10th of May at 8:30. You have any questions, sir?
You said it's the 10th of May?
Yes, sir.
Okay.
If you bond out of jail, that goes away. You just be on standby to get a notice in the mail for your next court date. All right, you have any questions?
No, sir.
All right, thank you.
All right, Your Honor, that's gonna be everybody on the calendar today.
All right, Deputy Ricani, thanks for your help today. We'll see you soon.
Yes, sir, thanks.
All right, thank you.
Please enjoy this pre-COVID bond court session. Starting in 3, 2, 1. Bond court.
Good afternoon, jail. Can you hear us and see us? Good afternoon, jail. Can you hear us and see us?
Yes, we can.
Okay, I'm going to start the video.
Okay.
Would you happen to have an extra copy of the docket? I couldn't download it from,
Yes.
it wasn't ready. Oh, okay. Yeah, I looked for it, but it was, I guess you have priority, yeah?
The printer was running out of ink, but it
Oh,
should be okay.
okay, great, thanks. On our end doesn't even show anything.
You are here for an initial appearance after detention. The rules of criminal procedure require that you be brought before a judicial officer within 24 hours of your arrest. The purpose of the initial appearance is to have a judge list the charges against you, inform you of certain rights that you had, and to determine the conditions of your release. You should have already received a copy of these charges. The judge will review your paperwork to determine if there was probable cause to arrest you. If the judge finds probable cause, he or she will then determine if you qualify for bond and what the monetary and non-monetary conditions of your bond should be. If the judge does not have enough information to make a probable cause determination for your arrest, the state may be given additional time to amend the paperwork. You should also be aware of the following rights afforded to you by the Constitution. You are not required to say anything at this proceeding. Anything you say can be used against you. You have the right to communicate with counsel, family, or friends, and if necessary, you will be provided a reasonable means to do so. You have the right to counsel. If you have not already retained counsel and cannot afford counsel, the judge will appoint you a public defender. For the purposes of today's initial appearance proceedings, you may be able to briefly speak with a public defender regardless of whether the public defender is appointed for you. In order to have an attorney appointed by the court to represent you, you must be financially eligible, as determined by the court based on financial information you provide. Therefore, if you have not already done so, please complete, to the best of your knowledge, the financial affidavits provided by the correction officers. An application fee for the services of appointed counsel will be assessed. If you do not speak English or Spanish, please let a corrections officer know. When the judge is ready, she or he will begin calling your case by name. Please listen carefully for your name. When called, please approach the microphone as directed by the corrections officers.
Not supposed to.
Thank you.
That's what happens all the time.
Usted se encuentra aquí para una audiencia o vista preliminar, después de haber sido arrestado. Las leyes y estatutos criminales del estado de la Florida requieren que se celebre una vista preliminaria ante un oficial judicial dentro de un plazo de 24 horas después de su arresto. El propósito de esta vista preliminaria es para que el juez pronuncie los cargos contra usted, para que se le comunique a usted sus derechos procesales y para determinar las condiciones de su libertad o fianza. Ya usted debería haber recibido una copia de estas alegaciones o acusaciones por escrito. Ahora, el juez revisará la documentación en su caso para determinar si existe motivo fundado o causa probable para su arresto y detención. Si el juez determina que existe causa probable o motivo fundado, entonces decidirá si usted califica para que se le otorgue una fianza, tanto como cuáles serían las condiciones monetarias o no monetarias de dicha fianza. Si el juez no posee suficiente información para determinar si existe causa probable o motivo fundado para justificar el arresto, se le concederá a la Fiscalía tiempo adicional para modificar la documentación. También se les avisa que posee los siguientes derechos que se les otorgan por la Constitución. A usted no se le puede obligar a decir nada durante esta vista. Cualquier cosa que diga podrá ser utilizada en su contra como evidencia. Usted tiene el derecho de comunicarse con un abogado, pariente o amigo, y si es necesario, que se les proporcione los medios razonables y disponibles para hacerlo. Usted tiene el derecho a un abogado. Si todavía no ha encontrado o contratado un abogado y no tiene los recursos para hacerlos, entonces el juez le nombrará un defensor público. Para el propósito de la audiencia preliminaria de hoy, se le permitirá hablar brevemente con un abogado de la Oficina del Defensor Público, aun cuando no se le haya nombrado para representarle en todo el caso. Para poder recibir la designación de un abogado, primero debe calificar económicamente según lo determine el juez. Esto será basado en la información financiera que usted proporcione aquí. Por lo tanto, si no lo ha hecho todavía, de la mejor manera posible, por favor, llene el formulario de insolvencia económica que se le ha proporcionado por el oficial de correcciones. Se le impondrá un recargo o costo por los servicios del defensor público. Si usted no habla inglés, por favor, hágale saber al oficial de correcciones. Cuando esté listo, el juez comenzará el proceso llamando a cada una persona y caso por su nombre. Por favor, esté pendiente para pasar adelante cuando escuche su nombre y cuando escuche su nombre, haga el favor de acercarse al micrófono, tal como le indique el oficial de correcciones. Muchas gracias por su atención.
Okay.
Good afternoon, Osceola County Jail. Can you hear me?
Yes, we can hear you, Judge.
All right, excellent. We're here for first appearances this afternoon. Just a couple general announcements on each case. I've found probable cause for all of the counts. On each case, if there's been an application for the appointment of the public defender, the clerk has found that they qualified, I will be appointing the public defender. First up, we have cases involving our interpreter. Our interpreter has been sworn. All right, let's go ahead and swear our Spanish interpreter.
You can raise your right hand. Do you solemnly swear and affirm that you will faithfully translate from English to Spanish and from Spanish to English to the best of your ability, so help you God?
Yes, I do. Fioro Leal, L-E-A-L for the record.
First case I have is Augustin Hernandez Lopez.
He bonded, Your Honor.
All right.
I don't believe so, Judge.
Okay. Well,
That's what the jail has indicated to me.
He has an immigration detainer, so I doubt he'll be going anywhere.
Yes, he bonded on this as to this charge, though.
okay. All right. Next is Jesus Montanez.
He's coming.
Montañez.
Let's go ahead and good morning, or excuse me, good afternoon, sir. Tell me your name.
Buenas tardes, señor. Diga su nombre.
Jesús Montañez.
Sir, you've been arrested and charged with the crime of battery and act of domestic violence.
Señor, usted fue arrestado un caso que tiene que ver con violencia intrafamiliar, con una agresión doméstica.
Sí.
Yes.
I do find probable cause for that offense.
Veo que por tal delito hay indicios de culpabilidad.
It appears that you qualify for release through the pretrial release program.
Parece que usted sí califica para que sea puesto en libertad bajo la supervisión del Departamento de Libertad Provisional.
I will order your release with the following conditions.
Y voy a ordenar su liberación, pero con las siguientes condiciones.
Number one, you're released through pretrial release.
Número 1, va a estar bajo la vigilancia del Departamento de Libertad Provisional.
Number two, you must maintain a separate residence from the alleged victim while this case is pending.
Y mientras este caso está pendiente de mantener residencia separada de la presunta víctima.
I'll let you go back to the residence where the incident took place one time
Yo voy a permitirle que usted vuelva una sola vez a la residencia donde ocurrió el lugar de los hechos,
in the company of law enforcement
con la compañía de un oficial de la fuerza pública,
to recover any personal items you need while the case is pending.
para que usted recupere algunos efectos personales que usted necesite mientras el caso está pendiente.
I'll order that you otherwise have no contact with the victim while this case is pending.
Y también ordeno que bajo ninguna manera ni forma tenga contacto con la presunta víctima mientras el caso está en curso.
I'll order that you possess no weapons or firearms while this case is pending.
Ordeno también que mientras el caso está pendiente no tenga ningún tipo de arma ni arma de fuego.
I'll order that you not consume any alcoholic beverages while this case is pending.
También le prohíbo que mientras el caso esté pendiente no consuma ninguna bebida alcohólica.
State any other conditions you're going to ask for PTR.
¿Qué pide la fiscalía?
No, Your Honor. Of course, no illegal drugs.
No, señor, y tampoco
Also order
drogas.
that you not possess or consume any illegal drugs.
Y también que no posea ni tenga ningún tipo de droga ilícita.
And I'll order that you be subject to random testing through PTR at your own expense.
Y también ordeno que el Departamento de Libertad Provisional le haga las pruebas antidrogas al azar, saliendo los gastos de su bolsillo,
To ensure compliance with this court's order.
para asegurar el cumplimiento con esta orden de la Corte.
That's the order of the court in regards to Mr. Martinez.
Eso es todo.
Next court date will be April 23rd in courtroom 4E.
La próxima comparecencia, abril 23, en la Corte 4E.
All right.
Thank you.
Do we have any other cases where we need the Spanish interpreter?
¿Algún otro caso donde se necesita el intérprete de español? Levanta la mano.
I see no hand, Your Honor.
All right. I have Sandra Perez Prado. Good afternoon, ma'am. You've been arrested on a warrant out of Lake County. The judge who issued that warrant set your bond at none. You remain on a no bond status pending Lake County coming and picking you up. Good luck to you, ma'am. Next, we have Chad Kerr or Kerr.
PD approved, Your Honor.
Sir, you have two matters before the court. The first is case number 16MM2154. In that case, you had failed to appear in court. Judge Draper issued a warrant for your arrest and set bond in the amount of $2,999. I'll stay that bond pending disposition of that case. Your next case is 2016 CF 3065. You were originally arrested on a warrant in that case. Subsequently, the state attorney's office filed an information charging you with 3 crimes. Madam Clerk, it's unclear to me what the bonds are, so I'm just going to announce bonds on each of the counts of the information. Sir, on count 1 of that information where you're charged with dealing in stolen property, I'm going to set bond in the amount of $10,000. On count 2, burglary of a structure, I will set bond in the amount of $5,000. And in count 3, receiving money from pawnbroker by false verification, I'll set bond in the amount of $150. I'll order that if you post bond in any of these cases, you also be released through pretrial release with weekly check-in. Order that you not possess or consume any alcohol or illegal drugs while this case is pending. That's a condition of your pretrial release and of your bond. Madam Clerk, do you have future court dates?
We do in case number 2016 MM2154. Next court date will be April the 15th, courtroom 4E, and in case number 2016 CF 3065, next court date is going to be April the 2nd, courtroom 4F.
All right, sir. Good luck to you. Next, we have Eric Raul Lopez.
PD approved, Your Honor.
Oh, okay.
All right, sir, you were arrested on a warrant on a driving while license suspended charge. It was in regards to a violation of probation in regards to that case. The judge who issued your warrant set your bond at none. I'll stay your bond at none at this time pending disposition of that violation of probation. Next is Keith Ott. I'm sorry, do we have dates for Eric Raul Lopez?
On demand.
All right. Next, we have Keith Ott.
Your Honor, we like to waive the reading of the charges.
All right, sir, you were arrested on a warrant. The public defender is requesting a waiver on the reading of the charges. I'll simply indicate to you that I'm staying all of the bonds that were previously set when the judge signed the warrant. Those will remain your bonds while this case is pending. Do we have future court dates for Mr. Ott?
On demand.
All right. Next, we have Leonard Roy Pasco.
PD approved, Your Honor.
Good afternoon, sir. You've been arrested on an affidavit of violation of probation. Your bond is set at none. I'll stay your bond at none pending disposition of your violation.
Next court date will be April the 11th, 8:45, courtroom 5A.
Next, we have Cameron Andrew Rubino.
PD approved.
Good afternoon, sir. You've been arrested on a warrant for violation of probation. The judge who signed that warrant sets your bond at none. I'll stay your bond at none pending disposition of your violation. Good luck to you, sir. Or, sorry, do we have future court dates for him?
April the 1st, courtroom 5F.
All right. Next, we have Anthony Dwayne Tadlock.
PD approved.
Does he just have one case in this packet of
Yeah.
people? Okay, all right, that's fine. Good afternoon, sir. You've been arrested on a violation of probation in regards to aggravated battery upon a pregnant person. You also qualify as a violent offender of special concern. The judge who issued your warrant set your bond at none. I'm going to stay your bond at none pending disposition of your violation proceeding. Your next court date would be?
April the 4th, courtroom 4F.
Next is Courtney Bromley.
Do you approve?
Got a witness as well. All right, we've got a witness here. Let's go ahead and swear the witness in.
Sir, if you can please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to enter in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
All right, tell me your name, sir. How are you connected to the defendant, Courtney Bromley? She was arrested yesterday and charged with the offense of aggravated assault with intent to commit a felony. You're the alleged victim in this case. We're not here to try the case today. I'm here to determine what conditions of release are appropriate for Ms. Bromley. What do you want to tell me on the subject of release?
Your Honor, I'm sorry, we can't hear anything.
All right, let's get that microphone closer to him.
Okay. My wife is pregnant with our first child.
Hold on, can y'all hear now?
Yes,
And
Your Honor.
Nothing at all, sir. Nothing at all. My mother called. My wife did use my registered firearm, but she did not. But she's pregnant with our first child. She doesn't have a habit of doing it. Never done it before, and wasn't going to do it. But my mother Glance, who also lives with us, and I'm the breadwinner, of course. I drive trucks, and so does my wife, and it's our first child. But sir, my mother saw from her room, which is adjacent to our room.
Sir, we're not here to try the case today.
I understand.
What is it
I
you're
just want you
asking me
to
to do or not do today?
let my pregnant wife go with my first child. Nothing was going to happen. Nothing was going to have happened. Won't happen. I mean, I understand, but the officers had to do their job. Yeah.
Well, sir, again, today's not the day to try the case. The state attorney has to decide whether they're going to prosecute this case or not. The only issue I have is to decide what conditions of release are appropriate. Normally, when acts of domestic violence are alleged to have taken place, I order that the defendant maintain a separate residence. Are you asking me to do that or not do that?
No, sir. Of course not.
Are you telling me that you want her to come home?
My pregnant wife with our first child, of course.
Okay. Are you telling me you're not in fear of her gaining access to one of your firearms and actually pulling the trigger this time?
The officers have taken the alleged weapon and so on.
Let me ask you this.
I'm in fear of that.
Let me ask you this. Are you willing to keep all firearms out of that home while this case is pending?
Absolutely, and I also want to say, I have lock boxes for my firearms. I've traveled.
That wasn't my question. Are you willing to keep all firearms out of that home while this case is pending?
Yes, sir. As well as this is our first child, and we're not have a bunch of money if bail is high. If you can take that in consideration as well.
I'm going to address that, sir. All right, Ms. Bromley, here's what I'm going to do. You need to listen very, very carefully. I do find probable cause for the offense. I am going to release you through the pretrial release program with the following conditions. Number one, you have weekly contact with pretrial release. Number two, I'm going to let you return to the residence where you live with your husband, as long as there are no firearms whatsoever in that residence. I'm going to order that you comply with any request of pretrial release to enter the home and ensure that there are no firearms in the home. I'm going to order that you have no hostile contact with your husband while this case is pending. That means no yelling, no screaming, no pushing, no shoving, certainly no pointing firearms or making threats to use firearms. State any other conditions that you're going to ask me to impose as part of PTR.
Your Honor, typically in a domestic case, the state always asks for alcohol, even if it's not included to the news. Arrest affidavit, the state asks for that. And RUAs, in addition, and I just want to say for the record that the state is concerned by the facts that forth in the arrest affidavit. The state does have concern about the hostile contact with the time. The state requires to have no contact order in case until such time as
We're having trouble hearing the state attorney.
I'll start over and I'll go as fast as I can.
I'm sorry.
It's okay. So basically the state is requesting that the court order no drugs, no alcohol, RUA, which is a typical state's request in a domestic related offense. The state would also like to put on the record that the state is concerned based on the facts as set forth in the arrest affidavit about the no hostile contact order. The state's preference would have been a no contact order, period, until such time as this matter could be addressed later in division.
So, Mr. Bromley, and let's get the microphone back over. So I want one more time. You indicate that you're going to make sure there are no firearms in the home. Do you understand that?
Yes.
Do you have any reason to believe that she has access to firearms other than the ones that you own?
No.
Ms. Bromley, I'm going to order that you not own, possess, control, or otherwise have any firearms or weapons while this case is pending. Given the fact that you're 9 months pregnant, given the fact that the alleged victim is here indicating that effectively this is a misunderstanding about what took place, again, I'm going to let you go back home, but please understand, Ms. Bromley, if there are any allegations that you violated my conditions of release, you should assume, number one, that I'm going to sign a warrant for your arrest. Number two, you should not assume that you'll get back out of jail if there's a violation of any of the conditions of release. Given the fact that you're 9 months pregnant, it's probably very difficult for you to care for your child if you end up violating and coming back to jail. Does that make sense?
Yes, sir.
And please understand, I'm not going to require you to go back and live there. I'm going to let you go back. If you think it's not actually the wise decision, that's up to you. Do you understand?
Yes, sir.
Do we have court dates for Ms. Bromley?
On demand.
All right. Next, I have Stephen Stone.
I can leave now.
You may. Good luck to you, sir.
PD is approved, Your Honor, for Mr. Stone.
Okay.
Yes, sir.
All right, sir. You have two matters before the court today. The first is your new arrest for possession of cocaine and possession or use of drug paraphernalia. I do find probable cause for those offenses. In those cases, I'm going to set bond on count one, the amount of $5,000, and I'll order pretrial release. If you post that bond, your conditions of release are weekly check-ins, do not possess any alcohol or illegal drugs, be subject to random drug testing.
Yes, sir.
For those, count two, the bond is $100 and pretrial release with the same conditions. Your other problem is that you were out on bond when
Yes, sir.
this took place in 2018 MM4311. In that case, I'm going to revoke your bond and hold you on a no bond status pending disposition of that case, or if the division judge assigned to the case decides to let you back out.
So wait, can I ask you what's going on then?
You got arrested for a new offense. I
Yes,
set
sir.
bond in that because I'm required to give you bond by law.
Yes, sir.
You were on bond when
Yes, sir.
this probable cause existed. In that case, I'm revoking your bond. In that case, you don't have a bond unless you get in front of your assigned judge in county court and that judge agrees to give you a bond.
Yes,
But
sir.
at this point, you're on a no bond status on that case. Your next court dates are as follows.
On
So-
demand.
I don't.
Okay. You can talk to the public defender. Okay.
There, that's all.
All right. Next is Matthew Shingler.
You bonded, Judge.
Okay. Next is Marilyn Torres.
PD approved.
Good afternoon, ma'am. You've been arrested and charged with 2 counts of battery, acts of, at least one of those is an act of domestic violence. We have a witness present. Let's go ahead and swear that witness in.
Sir, can you please raise your right hand? Do you solemnly swear and affirm that the testimony you're about to give on this case to be the truth, the whole truth, and nothing but the truth, so help you God?
All right, so tell me your name.
Victor Montanez?
How are you? Madam Defendant, are you okay?
Yes.
Are you sure?
That's my son, yes.
Okay, if you need me to reset your case till tomorrow, I'm happy to do that for you.
Okay.
Sir, how are you related to the defendant? And we're here today for first appearance. We're not here for trial of the case today. This is when I set conditions of release. Anything you want to tell me before I decide what conditions of release to put in effect?
This is my first time ever going through this with my mother, you know. She done what I did to her, she did to me, but it never got this serious. Never got this serious this far. She's a very independent woman. She raised 3 children herself. You know, you can't blame somebody from their past. But I love my mother no matter what, and what we go through. Still gonna have that love for her.
All right. Well, sir, whether you love the defendant or not isn't really the legal question for the court. The legal question for the court is what conditions of release are appropriate. Let me ask you this. 398 Greenwich Court, is that a home, apartment, or something else? Who owns that home? Okay.
Marilyn Torres.
And do you have any place to live other than that home? Okay. Who pays the bills to pay the mortgage or rent or whatever for that home? Okay. Do you work?
Not currently.
Okay. State, do you want to ask any questions of the victim while he's here?
No, Your Honor.
Your Honor, may I ask a question?
Go ahead.
I'm sorry, I don't have the police report right in front of me. Sir, if an incident like this might happen again, would you be afraid to call the police?
No.
Are you afraid of your mother?
No.
So you'd feel comfortable living with her?
Of course.
Okay. I have no further questions, Your Honor.
Sir, let me ask you this. Based on the way this report is written, it appears that there was also an issue, and maybe the whole issue was the fact that your girlfriend was staying with you in your bedroom? All right. So, do you anticipate that your girlfriend is going to continue to stay at the home?
Of course not.
All right, ma'am, here's what we're going to do. I'm going to release you through the pretrial release program with the following conditions. I'm going to order you have no hostile contact with your son, Victor. I'm going to order that you do weekly check-ins with pretrial release. I'm going to order that you not consume any alcohol or illegal drugs while this case is pending. I'm going to order that you have no contact whatsoever with the second identified victim, Thandia. I'm not sure what Thandia's last name is, okay? I'm going to order you have no hostile contact with your son. That means no yelling, no screaming, no pushing, no shoving. If he's making decisions that you disagree with as his mother, I think your options are to explain to him he's got to find a different roof to live under, not any other way of addressing the situation. Does that make sense?
Yes.
Victor, if you bring your girlfriend over to the house, it's going to put your mom in a situation where she's violating conditions of release, which means she could be arrested and taken to jail. So you probably need to figure out a different way to spend time with your girlfriend other than bring her around your mom. Does that make sense? I'll also order as a condition of pretrial release that you not possess any firearms or weapons. State anything else that you're going to ask for.
RUA, no drugs and alcohol.
I think I already said no drugs and no alcohol. I will order that you be subject to random drug testing at your own expense while this case is pending. Anything else, State?
No, Your Honor.
All right, that's the order of the court. Do we have dates for Ms. Torres?
Yes, Your Honor. Next court date will be April 23rd, 8:15, courtroom 4A.
Thank you.
And last, I have a defendant who originally came in as John Doe. It now appears to be Kyle Horton or Wharton.
And we have no application for this gentleman.
Okay. So,
Your Honor,
go ahead.
we'd ask that he be released on his own recognizance. I did argue probable cause on this case yesterday, and as of the police report stands now, there's still no probable cause, so we would ask that he be released on his own recognizance.
What's lacking in the probable cause?
There are no specific details as to the incident that occurred. All it is a legal conclusion stating that a battery occurred, basically.
State, do you have any additional information in regards to this case?
Sorry to cut you off, Judge. The state does not have any additional information. When I got the packet, I reached out to the arresting officer via email and have not received a response.
Okay. What are you asking me to do, State?
Your Honor, the state would argue that within the four corners of the arrest affidavit, the elements of the charged offense are spelled out. So the state would ask that the court find probable cause. And this case has already been subject to 124-hour reset, Judge.
Hold on.
Okay.
All right, argument by the public defender in opposition.
Yes, Your Honor. Again, the police report only states the legal conclusion. There's no information about what my client did or the circumstance surrounding the actual charges. And for that reason, we'd ask for him to be released on his own recognizance. As the state attorney indicated, this has already been reset once, and unless they can prove extraordinary circumstance, then this could not be reset again, Your Honor.
How do I release him on his own recognizance when we don't know who he is?
Your Honor, his identity was verified by fingerprints. At least that was the indication by PTR yesterday. His name is Kyle Horton, and
Corrections, are you concurring that you are comfortable that he's Kyle Horton?
Yes, Judge. The FBI came back with a positive match, like fingerprints. So it is Kyle Horton.
All right. State, the charging affidavit could be read in several different ways. It could be read as a statement of facts, or it could be read as simply a boilerplate conclusion that law enforcement oftentimes puts at the beginning of their affidavits to explain to the court what it is they believe the evidence shows. Then it's normally followed by a recitation. I think if it's open to being read either way, I have to read it in favor of the defendant. I'm also concerned, it's an open question in my mind, if one judge has already said no PC and reset it, whether I'm allowed to reweigh the decision that this doesn't constitute PC. I don't know the answer to that. No one's provided me a case on point on that issue. So under these facts and this procedural history, I'm going to order that Mr. Horton be released on his own recognizance. Sir, that means it's your obligation to make sure the clerk of the court has a correct and accurate address for you, because if the state attorney does charge you with the crime and they can't get you in to court, then a warrant's going to be issued and you're going to end up back in the Osceola County Jail proceeding through this case. Do you understand?
Yes.
All right. Tell me your name for the record.
Kyle Horton,
Tell me your date of birth for the record.
4/13/98.
All right. That's your the court in regards to Mr. Horton.
Thank you, Your Honor.
Next court date on demand.
I am out of paper, so that leads me to believe that we've handled all the cases. Is that correct?
No, Judge, we still have Varys Ryan.
Yes, Your Honor.
Yes. It looks like we thought that he had bonded prior, but he didn't. I apologize for that,
Okay.
and I'm going to print the arrest report, Your Honor.
All right.
Ryan Veras.
Jeremy Dale, whatever.
A couple people had bonded, so that may be one of them. She can file at the clerk's office. Yes, sir.
Do you have a Jeremy? I don't have it either. Might be from yesterday weekend, Ice. I know it's not wanting to print. I'm gonna try.
Does anybody else have a copy of the arrest affidavit in this case?
Right here, Judge.
I apologize for
And
that.
Judge, I have something to say about Mr. No, the one that had the immigration detainer. Because I remember now seeing on the corrections, yes. In the corrections case management, his bonds were paid in the morning, but then the bondsman came and retrieved those bonds when they found out that he had a immigration detainer.
I can have them bring him over here.
Why don't we just reset him for tomorrow, because I don't think he's going anywhere at this point in time.
Right.
No, he's not.
Correct, Your Honor.
All right. All right, let's call up Ryan Vares, or Varies.
This person, they're scheduled for arraignment on April the 3rd, 8:30.
Afternoon, sir. Tell me your name.
Ryan Vares.
Sir, you've got 2 charges before the court. The first is providing a false name or ID by arrestee. The second is resisting arrest without violence.
And Mr. Rivers, for the record, Your Honor, was denied above guidelines.
Okay. Sir, you don't qualify for the services of the public defender, so you're going to have to end up making your own arrangements to get an attorney in this matter. Just give me one moment. All right, so I found probable cause for each of the offenses. I'm going to stay your bond on false name or ID by arrestee at $500 and stay your bond on resist arrest without violence at $250. Do we have future court dates for him?
Yes, Your Honor. If still in jail, it will be April the 4th, if out, April 22nd in courtroom 4A.
The defendant has a second case, Judge. I don't know.
That's what I'm trying to ascertain is...
It's an on-view VOP for...
Sir, it appears that you were on probation at the time of this offense. Have they actually filed an affidavit of violation yet? Or is it just...
There's a detainer for Brevard County, Judge. It seems that they want to back in Brevard.
Okay, the VOP is out of Brevard County?
Yes, Judge.
Okay. Sir, there's a VOP out of Brevard County for you. They put a detainer on you. You'll remain in the Osceola County Jail pending Brevard County arrangements to pick you up and return you there to resolve your violation of probation. You gave him his dates here?
Yes, Your Honor.
All right, that's the order of court in regards to Mr. Varies.
That was my date.
I believe that's everyone, Your Honor.
All right.
Thank you. Have a good week.
Have a wonderful day.
You too.
Judge, thank you.
Okay. I'm getting ready to run downstairs.
They're waiting.
I know they are. Do we know if all the jurors are back?
I don't know yet, sir. Okay. I'll go get them right now.
Good afternoon, everyone.
Okay.
Good afternoon.
Hi, how are you?
That's the weekends, right?
And Judge, anytime you need criminal histories, just let me know.
Okay. I appreciate that.
problem.
It depends on the cases. A lot of times,
Some other very just...
the facts kind of speak for themselves, and I got a
Right.
pretty good sense of what I'm going to do. Other times, their history becomes more important. So.
Well, we're gonna go downstairs, do we?
You guys don't want to hang around with me, Judge?
Again, just depends on who you ask. I suspect Mr. Houston will tell you that I'm a horrible, terrible person. He'll tell you that for the next 30 years of his life.
Everybody wants to come work in our courtroom.
They don't want to?
They do.
Oh, they do.
Well, you know, there's this old saying, allegedly Winston Churchill said it, but, you know, sometimes people just say everything was said by Winston Churchill, but he said once, if you're going to kill a man, you can at least smile at him. So, my theory is we all have jobs to do.
Yeah.
We should try to be as stress-free as possible.
I agree.
And
Sometimes the job involves telling people bad news.
I do agree with that.
Okay. Thank you.
Thank you. You need to text me.
Take care of these and
All right, if council please announce their names for the record.
Good morning, Your Honor. My name is Barrington Irving on behalf of the state of Florida.
Good morning, Your Honor. My name is Fernando Perez on behalf of the Office of the Public Defender.
All right. The first files I have are James Smith. Your name, sir?
Nathan Smith.
All right, sir, you've got a couple of things here. Burglary of an occupied structure, bond $5,000. Petty theft, bond $250. And another case involving disorderly intoxication, bond $250. So it looks like the total bonds would be $5,500. Now, sir, do you want me to appoint a lawyer for you?
Sure, yes, sir.
The Office of the Public Defender is appointed. Division 10 on the felony case and A on the misdemeanor. Your name, sir?
Yeah, Boyka.
All right, sir. Let's see. Sir, you have a Volusia County warrant, apparently. Your bond totals $575. Looks like it's a battery charge. You'll be transported, sir, to Volusia County to answer to the charges there. William McLeish?
Yes, sir.
All right, sir, you've got a set of charges here. Retail, petty theft, bond $500, resisting an officer without violence, bond $100. Do you want me to appoint a lawyer for you, sir?
I'm already been appointed.
I couldn't hear you, sir. The
Already
question
been-
is,
already been.
do you want me to appoint a lawyer for you?
I think I already got a public defender.
All right. Public defenders are lawyers. The Office of the Public Defender would be appointed in regard to this case.
Oh, yes, sir, yes, sir.
So your bonds totals $600.
He is an open case. He's out of bond on the case.
He's out on bond in this case. You want to take any action on it or no action?
Let's see. It's the same charges, isn't it? Retail theft and resisting without. On that, the new one?
This is petty theft and resisting without. But this is, they didn't print it out for you. Hold on. The other charges are robbery and resisting officer without violence.
All right, the bond on which you are released at this time, not the new case, but the one on which you're released, is revoked. All right, next case is that of Kenneth Hardy. All right, your name, sir?
Kenneth Hardy.
Mr. Hardy, you've got a charge here of disorderly conduct. Your bond at this time is $250. Do you want me to appoint a lawyer for you?
Yes.
Public Defenders appointed, Division A, offer from the state.
One second, Your Honor.
Yes, 1 second as well, Your Honor. I don't believe this man was listed in the move-ups. Oh, I'm sorry, I'm looking at felonies, that's silly. There we go. City and county ordinances.
State does not have an offer, Your Honor.
All right. All right, that's it then.
How long am I gonna be in here on that?
We have to get a question yet, so you want to get about that one. So, we want, definitely.
I don't have it. The judge, can he give me time served?
All right, the next file is that of, looks like Adolfo Salinas Soba Bar. Sir, what is your name, please?
Adolfo Salinas Ovalbarro.
All right. Sir, you've got an open container charge. Do you want me to appoint a lawyer for you?
Yes.
Yes, Your Honor.
All right, the public defender's appointed. Offer from the state.
Your Honor, the state has no offer on this case as well.
All right. If a plea of guilty or no contest is entered, the court would sentence this gentleman to 5 days, credit for 2 days, time served, and court costs totaling $273 payable within a year, adjudication of guilt.
Okay.
Is he a brand new state attorney?
My client would like to accept the court's offer at this time and enter a plea of no contest.
All right. There's a factual basis stated here in the arrest affidavit. The plea would be accepted, and that penalty would be imposed, adjudication, and 5 days credit for 2, and the court costs as previously announced. Yeah, you're right.
Three more day, today?
Yes, sir.
All right, the next file is that of Kenneth Jeter.
Good luck, sir.
Is that you, sir?
Kenneth Jeter.
All right. Mr. Jeter, you've got a charge here of trespass on property after warning. Is there any offer from the state on this case?
No, Your Honor.
All right. Office of the Public Defender is appointed to represent you. If a plea were to be entered, there would be an adjudication, 5 days Orange County Jail, credit for 2 days time served, court costs $323 payable within 1 year.
I'm not saying that. I got nothing to do there. I'm not touching nothing. Simon.
Sir, one moment. Apologies, Your Honor, sir. Your Honor, apologies. Would a possible, apologies, yes. So that's just what we're looking at right now, sir. I'm going to say that. Be here 3 days, sir.
No, I'm letting go. All the time. Let me go. All
All right, if there's no decision by the defendant at this time, we're going to move on.
Okay, good luck, sir. Wait, hold on.
No, he said hold on. He said hold on. He
There
said,
you go, that's our paperwork.
Your Honor, the bond was set in this case for how much?
Sorry, sir, good luck, sir.
500.
Thank you.
Good luck, sir.
And the PD's appointed, correct?
Yes.
Yes.
Mr. Barrington. Okay.
Linda Nelson. Your name, please.
Linda Nelson.
All right, Ms. Nelson, you've got a charge of trespass on property after warning. Do you want me to appoint a lawyer for you?
Public defender.
Public defender's appointed, Division A, $500 bond. Now, on this case, is there any input from the state?
Your Honor, the state would be prepared to offer 5 days in jail, no return to the scene, and court costs.
Would the state, wait, no. Would the state be willing to consider a credit time served offer? My client does not seem to have an extensive history, and she is correct. Nor does he seem a particular danger to the community.
How much credit does
2 days.
3 days?
2 days.
2 days.
Well, she's been in here 2 days, right? Okay, she's been in
I
here.
want to plead guilty to the charge.
Your Honor, the state will offer 2 days. We'll do a credit time serve offer.
Kill me out there.
Ma'am, we have an offer from the state. It's adjudication, credit time served. You can get out today.
I don't want to be out there around those people. They out there trying to kill me.
Okay, so you don't want to accept the offer?
No.
Okay.
All right.
There's a $500 bond. Okay, wait, hold on. Let me give her her paperwork. There you go. Good luck, ma'am.
Mario Aponte. Right, reset. The next file then is that of Babalu Jakeshan, if I pronounce that correctly.
Jackie Sean Babulau.
All right, sir, you have a set of charges here. Burglary of a structure, bond $5,000. Petty theft, bond $100. Criminal mischief, more than $200, less than $1,000, bond $100. and dealing in stolen property, bond $150. Now, sir, do you want me to appoint a lawyer for you?
Yes.
Office of the Public Defender is appointed, Division 17.
Serious charges, so you're going to get this with our office, but you can. Okay, so I cannot do anything at this time, well, you can't, but you'll have to have them, or you can call your chief now. So agree, go with that, you do, 5,100, now from a bit, bond, like 500.
In total?
No, that'd be 500 for the top first one. But good luck, sir.
All right, next file is that of David Benson. There are two charges here, possession of cocaine and no valid driver's license. Sir, do you want me, are you Mr. Benson?
Yes, sir.
Do you want me to appoint a lawyer for you?
Yes, sir.
Public defenders appointed, Division 16 on the cocaine case, and Division A on the no valid.
You said Division 80 on no valid?
Say again?
You said Division 80 on no valid?
No, Division A is an apple.
Hey, thank you.
She qualifies for PTR.
And what are the charges again?
Possession of cocaine and no valid driver's license.
Now, when they qualify for PTR, does the judge always bring it back? All right, even though he qualifies for PTR, that qualification will not be considered at this time by the court, so the bonds remain at a total of $1,500.
Your Honor, if the defense may be heard, my client does not have an extensive history, and the facts of the case show it was, by the estimates of the officer, allegedly a small baggie. Would the court be willing to reconsider in light of the fact that my client has no extensive history and the facts of the case don't rise to a level to completely discount PTR?
Well, in regard to the cocaine case, then the court would reduce the bond to $500 as opposed to $1,000, and the other bond remains the same. And that was $500.
Understood.
Okay. All right, Todd Brule.
Yes, sir.
Sir, you have a set of charges here. Battery on a person 65 years of age or older. You're in a no bond status in regard to that. And a charge of simple battery on which the charge is $500 with conditions. No contact directly or indirectly with the victim or co-defendant, witnesses, maintain a separate residence, don't return to the scene of the offense, don't possess or consume any alcohol or illegal drugs, don't possess any weapons or firearms. So, sir, do you want me to appoint a lawyer for you?
Yes, please.
All right, Division 19.
Apologies, Your Honor. Did we say the bond as the battery, and did we set no bond as to the battery on the alleged battery on person of 65 age or older?
Correct.
Thank you, Your Honor, for the clarification. Here. So we're here. Your Honor, you can't bond out at the moment. So that's what we're doing right now. I wish you good luck. Please get in touch with us when you can, sir. Thank you.
All right, next case is that of Kenyon Bryant. What is your name, sir?
Kenyon Bryant.
All right, sir, several things here. A warrant here for robbery by sudden snatching. Your bond there is $5,000. You're released on a possession of cocaine within 1,000 feet of a place of worship, and that bond at this time would be revoked, and I believe that's all. So Division 10 on the new case.
Your Honor, I'm on that case, sir. So we're going to see what happens there. But if you have any questions on that, you're going to want to talk with the public defender that you assigned. Yes, at the moment you can't bond out. So you're going to get in touch with your office when you can. This is going to be an ongoing matter. I want to wish you good luck.
Thank you, sir.
All right, your name, sir?
Isaiah Cordero.
Mr. Cordero, sir, you've got a warrant here that was issued for failure to appear on possession of methamphetamine, possession of 20 grams or less of cannabis, and possession of drug paraphernalia. And it states here you failed to appear, so you're in a no bond status. Now, do you want me to appoint a lawyer? Was the public defender previously appointed?
Yeah, public defender.
All right, public defender is appointed, if not reappointed, Division 16.
That may not be an immediate excuse upon the jurisdiction. You're going to get thus. That is not the most. I was incarcerated when I wanted that to happen. Okay. Thank you.
All right, next file is that of Kareem Ford.
Yes, sir.
All right, sir, two things here. Failure to appear capious on a delivery of cocaine case. You're in a no bond status in regard to that. And then, let's see. Yes, looks like you got another case from 2012, failure to appear. Both of these are Division 14. Appears to be two separate cases, two separate differing case numbers. Sir, was the public defender previously appointed?
Yes.
Yes, yes, sir.
All right. That's Division 14 on both. All right, the next file is that of Joseph Hill. Is that you, sir?
Yes, sir.
All right, Mr. Hill. Sir, you've got a charge of possession of cocaine on which your bond is $1,000. I don't have any financial affidavit filled out for you. Does the public defender know if you've had prior representation?
I do not know at this time, Your Honor. Not in this current case. I do not believe he has a public defender assigned to this case.
Well, let's see. Mr. Hill, are you intending to hire an attorney?
No.
Do you want me to consider appointing the office of the public defender at this time?
Correct.
All right, public defender is appointed, Division 12.
Which one applies for PTR?
All right, so ordered.
Call what name?
This one.
Today?
Just right.
Yes.
Qualifies for PTR.
Yes.
Okay.
Granted?
Okay.
All right,
Okay.
Michael Hoyman is the next case. Is that you, sir?
Yes, sir.
All right, sir, a set of charges here. Burglary of a structure, bond $3,500. Grand theft, third degree, more than $300, less than $5,000, bond $150. Dealing in stolen property, bond $150. Receiving money from a pawnbroker with false verification, bond $150. And criminal mischief, more than $200, less than $1,000, bond is $100. Now, sir, do you want me to appoint a lawyer for you?
Yes.
Office of the Public Defender is appointed, Division 14.
Yes. I believe they are. Just right off the sorry. Now, I have an appointment with the that could have on so that'd be what we do. We have a person that would pop on. Very awesome.
All right.
I don't know if good luck, sir.
Bless you. All right, next file is that of Mark Jokin.
He bought it, Your Honor.
All right. Then Ronald Meekins.
Yes, sir.
All right, sir, a set of charges here. Petty theft with 2 prior convictions, 2 counts of that. Your bond is $1,000, count 1, $150, count 2. Do you want me to appoint a lawyer for you, sir?
Public defender, sir.
Say again?
Public defender.
All right, Office of the Public Defender is appointed, that's Division 12.
Yes, we want to come on down.
Your Honor, Wayne Malier is behavior. Malier.
Say again?
Wayne Malier is behavior.
All right, reset. All right, next file I have then is that of James Miller. Is that you, sir?
Yes, it is.
All right, sir, 3 cases apparently. Retail theft, bond $2,500. Resisting a merchant, bond $100. And then another case of retail theft, more than $300. Your bond is $1,000 in regard to that allegation. And lastly, another retail theft, more than $300, bond $1,000. Now, sir, do you want me to appoint a lawyer for you?
Yes.
All right, we have Division 15, the public defender's appointed. Division 15, first case. Division 11, second case, and 15 again on the third case. Next file I have is that of Kevin Morris.
Yes, Your Honor.
All right, Mr. Morris, you've got a set of charges here. Possession of heroin, bond $1,000, and possession of paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Public defender, Your Honor. I believe I signed up for one already today also.
All right, the Office of the Public Defender is hereby appointed on these charges. That's Division 19.
He qualifies for PTR.
What do other judges deny PTR if they qualify? All right, bond or PTR on that case. Yes.
No, you're not RR. You just get out of bonds without having to pay bonds. But it's still not the case. The cause when you can.
All right, next file is that of Lentice Owens.
Yes, yes.
All right, sir, you've got a charge here of failure to report name or residence change as a sex offender. And at this time, you're in a no bond status. Do you want me to appoint a lawyer for you, sir?
He's asking if you want a public defender.
Office of the Public Defender is appointed Division 15. All right, the next file is that of Anthony.
Apologies at the moment to confer with records. Yes. Apologies, Your Honor. Apparently my client does qualify for bond status. Would it be possible, considering he does not have an extensive history, if he could receive a bond today?
That what?
The failure to report cases, they usually get a
All right. Well, I'm going to then set a bond at this time in the amount of $2,500.
Your Honor, the state asks that the bond be set at 5,000.
Let me look here. All right, having scanned the paperwork once again, the state's request to be granted be the higher amount, 1,000 or whatever. 5,000. All right, now the next file is that of Anthony Parton. Is that you, sir?
Yes, sir.
All right, sir. Several counts here, charges. Carrying a concealed weapon by a convicted felon, bond $5,000. And then possession of a firearm by a convicted felon, bond $150. And then looks like 5 counts of possession of ammunition by a convicted felon, bond $150 on each of those 5 counts. Now, sir, do you want me to appoint a lawyer for you?
Yes, sir.
Office of the Public Defender is appointed, Division 22. All right, next file I have is that of Dion Richardson.
Apologies, Your Honor, I'm still getting my, Your Honor, may I have a moment to make a quick call to office? I appear to be running low on paperwork, and I need them to send a paralegal down with replacements.
All right.
Apologies. Just a moment to return to my desk. Actually, on second thought, Your Honor, let's do my, Mr. Richardson, and then I need to head upstairs for a brief 2-minute, a brief 2-minute absence to retrieve more paperwork. I apologize, there was a lapse in my office's workings. So,
What's the total amount of time you're requesting?
2 minutes.
What?
Or 1 moment, actually. If I may confer with a colleague of mine. Yes. Hi. Apologies.
What did he say?
It appears that we're able to continue the proceedings.
All right. Then we will proceed. The next case is that of Dion Richardson.
Yes, sir.
All right, Mr. Richardson, sir, you've got a charge here of grand theft 3rd degree of a motor vehicle. Bond in your case is $1,000. Do you want me to appoint a lawyer to represent you?
Yes, sir.
All right. Division 15, public defender appointed.
Sir. Am I eligible for I mean, I'm a foot.
All right, next file is that of Emilio Serrano.
Yes, sir.
All right, sir, you've got a set of charges here. Burglary of a conveyance with assault or battery, no bond at this moment. Possession of a firearm in commission of a felony, no bond. Now, I don't have any application for criminal indigent status. Have you been previously represented by the Office of the Public Defender?
I choose go private.
Say again?
I'm gonna get my own attorney.
Oh, you're going to hire your own lawyer?
Yes.
All right. Well, for what it's worth, that's Division 15. All right, that concludes the case then. All right, next file is that of Logan Shumpert. Is that you, sir?
Yes, sir.
All right, sir, a set of charges here. Possession of cocaine, bond $1,000. Possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Office of the Public Defender is appointed, Division 20.
Records, I see that he didn't qualify for PTR, but the reason was additional notes. Was the detainer was it concerning the DNA retainer, or?
Wait for the APHIS to be completed, because he was interviewed.
Okay.
Waiting on APHIS to be cleared.
Okay, so the APHIS hasn't arrived yet. All right, let's see here. Unfortunately, there's not much we can do at this time. Your Honor, my client has nothing in the way of a record. Would some leniency on the first count be possible at this time?
All right, what's the state's position, if any?
Your Honor, the state will leave it to your discretion.
All right. The bond on count 2 would be reduced to $100 from $500. Count 1 remains the same.
Thank you, Your Honor.
All right, the next file is that of James Starnes. All right, your name, please.
James Starnes, sir.
Mr. Starnes, you've got a charge here, failure to report name or residence change as a sex offender. The bond was set at $10,000 by the judge. Do you want me to appoint a lawyer for you, sir?
Yes, sir, if you would, please.
All right, Office of the Public Defender is hereby appointed. Division 16.
All right.
Okay.
When the defendant doesn't fill out the financial affidavit, do the judges appoint the public defender?
All right, the next file is that of Justin Upton. Say again? All right, reset. All right, next case is that of Alan Waters.
TJ, sir, is my first name.
All right, T.J. Allen Waters, right?
Yes, sir. Good morning.
Okay, sir. All right, you've got a set of charges here, fleeing, attempting to elude a police officer, and driving while license suspended. Now, as to count one, you had been you did have that bond. It was originally set at no bond. At this time, the court is setting the bond at $10,000. As to count two, driving while license suspended, that bond is, instead of $2,500, is reduced to $250. Do you want me to appoint a lawyer for you, sir?
Please, sir.
All right, public defenders appointed, Division 22. All right, the next file I have is that of Jeffrey Ragg.
Yes, sir.
Sir, looks like a set. No, here. All right, you're out on bond on a charge of driving while license suspended or revoked with knowledge, second conviction. You have a new case here, bond of $2,500 on driving while license revoked as habitual offender.
Yes, sir.
So, looking at the history here, the bond on which you are released is revoked, and the new bond is the $2,500. Do you want me to appoint a lawyer, sir?
Yes, do that mean I can bond out today?
All right, that's Division 11.
So the original bond, $2,500 on the one you revoked, is the $2,500 too, or no bond? On the one you revoked?
The new case is $2,500.
Okay.
The old one is revoked.
Revoked, no bond.
All right, we'll have to see about that then. Don't worry, but, so call us when you can about that. This is in line with this as well, so good luck. Okay. Bonding for driving license to revoke. Since you're already out on bond, you're gonna be exact as revoked. So that means you can't bond out just yet. All right. Good luck, sir.
All right, next files are that of Bobby Wyrick.
Yes, sir.
Is that you, sir?
Yes, Your Honor.
All right, just a second. All right, Mr. Wyrick, 3 cases looks like. Grand theft, third degree of motor vehicle, bond $1,000. Resisting an officer without violence, bond $100. Then another case of failure to appear, and the judge in that case set you at a $500 bond. And then another failure to appear, and that bond likewise is set at $500. So we have $1,000, $100, $500 and $500. Now, sir, do you want me to appoint a lawyer for you, or do you already have a lawyer?
I would like for you to appoint me one, sir.
All right. Public Defender appointed, Division 17 on the grand theft, et cetera. Division 85 on the first failure to appear, and 61 on the second failure to appear. All right, next file I have is that of Mikhail Briggs.
Yes, sir.
Sir, you've got a charge of open container. Bond is $250. I don't have any request for a lawyer from you. Is there any offer from the state on this case?
No, Your Honor.
All right, in regard to this, sir, if you wish to enter a plea of guilty or no contest, you'd be giving up, of course, your right to a trial, but the court would adjudicate you guilty, sentence you to 2 days with credit for 2 days' time served, impose court costs, $223 payable within 1 year. You don't have to accept that offer. You may if you want.
I accept that, sir.
All right, so ordered. And I believe that's all then.
Yes, sir. Thank you, sir.
Was a public defender assigned to Mr. Briggs' case?
No, didn't fill out the request. All right, Paul Clark.
Behavior, Your Honor.
All right, reset.
Behavior reset?
Mel Dawson, or
Yes, sir.
Dawson? Is that you, sir?
Yes, sir.
All right, sir, you have a case here involving an allegation of disorderly conduct. Bond is $250. Do you want me to appoint a lawyer for you? All right, public defender is appointed, Division A. Now, in regard to this case, is there an offer from the state?
No, Your Honor.
All right. And what plea would be entered by the defense at this time?
Your Honor, my client does not have a very large history. I think for this particular charge, an adjudication with 2 days going towards a 5 days sentence would be more than sufficient to see justice done on this issue.
All right. If a plea of guilty or no contest were to be entered, the court would impose an adjudication, 3 days, credit for 2 days, time served, and court costs payable within 1 year.
Okay, so,
273.
so you did not say you were ready for it. You're ready for it. Apologies, Your Honor. It appears that something has come up. The defense would like to thank Your Honor for the 5-day offer. But it appears that my client is trying to make a job interview in the morning, not to push matters further. Would a possible CTS be possible in this case, or would Your Honor rather stick with the original offer, which the defense would accept if it were?
All right, I'm sorry, the copier's going, I can't hear you. Speak up or yell or something.
There are important life circumstances for my client tomorrow morning I was only just made aware of. The defense, therefore, while thankful for the judge's offer, would like to ask if a possible CTS was issuable. If not, the offer as stands by the judge would be acceptable.
All right. What did he say? Did you hear?
Oh, okay, I'm sorry. 3 days.
I'll take it. Yes, sir.
All right. Apologies, Your Honor. There was a miscommunication.
Yes, sir. Yes, sir.
He's gonna take it off.
I'm not.
Yes, 2 days, 2 days. Yeah, you get out. Because you don't get 2 days. I thought it was 5 days. Yes. He does. Okay. Apologies for the misunderstanding, Your Honor. One moment.
Offer 3 days.
3 days, 2 days served.
AG court costs.
AG court costs. All right. Payable. Yes, and then today. Good luck, sir.
All right, the next file is that of Darnita Carter.
Yes.
Ma'am, you have a set of charges here. Possession of paraphernalia, bond $500. Loitering or prowling, bond $100. Securing another for prostitution, bond $100. So the total bonds are $700. Do you want me to appoint a lawyer for you?
Yes.
All right. Office of the Public Defender is appointed. That's Division A.
I do not believe you qualify for PPR at this time. All right, so you're going to be turning on this case. You're on my bad. How much you want? Yeah, I'll pay the bond, I make the case. So I'm paying for possession. At this time, there's not much else to be done. I want to wish you.
All right, next file is that of Damian Jones. Is that you, sir?
Yes, sir.
Sir, you have a set of charges here. Simple battery, bond $100. Resisting an officer without violence, 2 counts of that. $500 on one, $100 on the other for bond. Trespass on school grounds or facility, bond $100. And another case involving simple trespass, bond $100. Now, sir, do you want me to appoint a lawyer for you?
No, sir.
Office of the Public Defender is appointed. Now, let me add one other thing, and that is that you're out on bond on a petty theft and resisting without, and you were ROR'd. That ROR will stay just as it is. All right, now, so the Office of the Public Defender is appointed, and Division A.
Good luck.
All right, next file is that of Dennis Molenda. Is that you, sir?
Yes.
Mr. Molenda, you have a set of charges: petty theft, bond $100, trespass on property after warning, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right, Public Defender is appointed, Division A. All right, the next file is that,
Your Honor, apologies. I forgot to inquire if the state had an offer on this case.
No, the state does not have an offer because I do not have the history, and petty theft is an enhanceable crime.
Did you, I have the history right here if you would like me to give it to you. Permission to approach the state, Your Honor.
That's a lazy question.
Yeah, all right. Yeah, the state would not be prepared to make an offer on this case.
okay,
That's our number. Please call me.
okay.
I want to wish you good luck.
All right, then that's all for the moment. Michael Silver,
Yes, sir.
is that you, sir?
Yes, sir.
All right, sir, you're released on a bond on a drug case. That bond is stayed. New cases or allegations: trespass in a conveyance, bond $100, resisting an officer without violence, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public Defender is appointed, Division A.
You can take any action on
No, stay.
it? Stay.
Apologies, Your Honor. I forgot to write down for the benefit of my client. Was the bond in the first appearance detainer or matter thereof revoked or?
What do you want?
No. Okay, no action on the first appearance detainer. Apologies. Thank you, Your Honor.
All right.
All right. Take the paperwork, sir. I want to wish you good luck. Please pause when you. You got a bond. You don't have to. Okay, this was stayed. No action. you have a bond there and a bond there. 100, 500. You can bond out, sir. Good luck, sir.
All right, next file I have is that of Rosalind Smith. Is that you, ma'am?
Yes.
Ms. Smith, you've got a charge here of trespass in a conveyance. Your bond is $500. Do you want me to appoint a lawyer for you?
I wasn't sure if I needed one or not, but I said yes.
Well, the Office of the Public Defender would be appointed Division A, and that will do it for the moment.
She qualifies for PTR.
All right? So ordered.
So when I get out.
Get out today, no bond, but tell them I'm going out. Okay, good luck.
Thank you.
All right, next file I have is that of Wally St. Julian.
Yes, sir.
Sir, you've got a St. Lucie County case here, and let's see, failure to appear, and you're in a no bond status right now, so what happens is you would, let me look here. You would be transported to St. Lucie County to answer to the charges there.
You mind repeating that for me one more time, please?
All right, the only files I have left are the 33-day motions. Say again?
Bond hearings, you have some bond hearings on there.
Ah, all right. Motion for release of defendant on ROR, parentheses, 33-day motion.
No, that's not him though, that's not the defendant, the guy that's, this is Mr. Gross. Yeah, you got quite a few there listed.
Oh,
I just didn't know what order they was putting on it, so, yeah.
Gross. Two. All right, next files I have here, or rather file, is motion, the 33-day motion on William John Gross, input from the state.
No objection to RR, Your Honor.
All right. So ordered.
It says Vega, isn't it? Is there something after Vega?
Thank you.
Yes, sir.
Good morning, Your Honor. Jace Thompson on behalf of the Office of the Public Defender. For the record, I wanted to, if at all possible, address the case of Todd Brule that you heard earlier. And that's case number 19 CF 3467.
He said from earlier.
What's the?
It's Gomez.
Todd Brule, Bruehl.
19 CF, you said?
19 CF 3467.
All right, that was a charge of battery on a person 65 years of age or older, no bond, and battery $500.
Yes, Your Honor. On the no bond, he is actually entitled to a bond under Florida law. The thing about it is this is a domestic violence case, and it was supposed to be heard in courtroom 2 and not courtroom 1. And I would ask for it to be transferred to courtroom 2, Your Honor.
All right, so ordered. And the order, if any, entered by this court in courtroom 1 would be vacated and set aside.
Thank you, Your Honor.
Next, we got Vega Gomez.
Your Honor.
All right, now, I've got, looks like 2 cases on Christopher Vega Gomez, cases ending in number 1297 and 1298.
Your Honor, if the defense may be heard at this time, it is the decision of the immediate representative of the Office of Public Defender to withdraw these motions and if to reinstate them then at a later date.
Can you hear what he's saying?
Speak into the mic, because we can't hear you.
Apologies, Your Honor. As I was saying, it is the decision of the immediate representative of the Office of Public Defender to withdraw the motions put forth before you today on behalf of Mr. Gomez at this time.
All right, so noted. And they're withdrawn. All right, now, I've got another file here. It's Elijah Kraft, case ending in number 1739. So, input from the state.
Elijah Crabb. 1 second, Your Honor.
I'm sorry, what was the matter? Apologies. What? I only have a motion to withdraw before me. What was the other matter that we're tending to at this moment?
That's a 33-day.
Oh, okay. Actually, Your Honor, before we commence the 33-day motion, I apologize. I must ask to hear a motion to withdraw from the Office of the Public Defender on behalf of one of our clients. All
right.
See here. Would the judge like a copy of this motion presented to you at this time? All right.
All right.
In that case, I'm going to require either the assistance of records to print it out or to, or if you would like to look at it temporarily, I can go over it. All right. Apologies. There you go.
These are the two on the wall.
All right, I assume there's no input from the state.
No, Your Honor.
So ordered, allowing withdrawal.
Thank you, Your Honor.
Next, we have a new
All right, Ayub Abdulrahman, if I
Yes, sir.
pronounce that correctly.
Oh, you did wonderfully.
All right, now, sir, this is noted as a determination of counsel on a set of charges: arson of a conveyance, possession, manufacturing, transporting a firebomb. And I have now been furnished an application for criminal indigent status. Do you want me to appoint a lawyer for you?
Yes, sir.
All right. Office of the Public Defender would be hereby appointed. You qualify according to the paperwork here. And that's Division 11.
Your Honor, if I may receive clarification, what was the current bond status of the public defender's newest client?
What was the what?
What was the bond status?
5,000, count 1, 150, count 2.
5,150. Okay.
Here for,
All right, we're gonna have to see what we can do, sir. To get the information. I'm having a case right now, so I can't get the search. What's your name? Fernando, but I'll be standing the post here. You'll be working with one of our guys. Thank you. All right, good luck, sir. Okay, thank you. Thank you.
All right, I have a file here on Mark Kane, and it states plea that he has 38 days credit. Any input from the public defender?
Was Mr. Kane assigned a public defender for his case?
Yes.
Yes. Public defender was appointed by Judge Wish.
A moment.
It was originally disorderly conduct. Has 38 days credit.
I apologize, Your Honor. I don't seem to have his paperwork. Was he a reset?
Hmm?
No, he was an add-on docket.
Oh.
Add-on docket.
I see. Wow. A moment to confer with State. Mr. Barrington, do you have Mr. Kane's complaint sheet on you?
Is it Antonio?
Oh, no. Mark Kane. One moment, let me pull up my laptop. All right, actually, apologies. If we may, the account was disorderly conduct originally, right?
Aye.
Yes.
Okay. In that case, if he has been appointed a public defender, then would an adjudication with credit time served be possible at this time if my client were to make a plea to the bench?
This is for disorderly conduct for Mark Kane. We do have an offer. The offer is a withhold $223 in court, $223 court cost, and a $10 filing fee on the disorderly conduct charge.
The withhold to go to the 13th. Can I tell?
This is on PTO. Then.
Good. Apologies for the mix-up, sir. All right, thank you, Mr. Barrington.
The 223s are fine.
My client would like to accept the state's offer at this time and plead no contest.
All right, and for plea purposes only, stipulate to a factual basis. What? Hmm? Is this Kenyon?
I prefer to factual basis. I think that's the factual.
Yes. Apologies, a moment to confer with state.
All right, there's
Oh, I see, yes, that was the problem. Okay.
notes on the paperwork I have, says plea 38 days.
Ah, I see, yes. Plea, motion, 38 days. Okay, yes, I have that now. One moment. Okay. Okay, so we're not stipulating to the factual basis, we just wish to take the offer from the state. At this time, Your Honor.
Stipulate to the factual basis for the purpose just of the plea.
Okay.
Yeah, just for the purpose of the plea.
Okay, apologies, Your Honor, we would stipulate to the facts of the case just for the purposes of the plea, Your Honor.
All right. And let's see, for the record, in case it wasn't previously stated, case number 2019 MO 239. And the note, once again on the file, says be a plea with 38 days. And it looks like, let's see, arrest date was February 3rd. So that's at least 38 days, I believe.
Your Honor, and just for record purposes, the offer is a withhold court cost, $10 filing fee, and credit time served for the days that he spent in OCJ.
All right. And is that the guy's name?
Yes, just get in touch with the officer and you can handle the other matter.
Yeah.
All right, good luck, sir. Apologies for the discrepancies, Your Honor.
Let's see. Now, I have another 33-day motion here, Elijah Kraft, case ending in number 1739. state.
Your Honor, denied for Elijah Kraft, sent to clerk file. It was sent to clerk filing. ID is 86258948.
All right,
So the state asks that this motion be denied because this case was sent to the clerk, and the filing ID is 86258948.
all right. So order denied.
That's the rest of them.
So all of these are.
All 30 days, yeah.
All right, now I've got a pile of 33-day motions here. Ryan Beamer, 18, CF 18342.
Your Honor, the state is also asking that this motion be denied. It was filed 3/12. It was filed yesterday, Your Honor.
All right, so ordered. Then another case here, Christian Cutright, case ending in number 1208.
Your Honor, the state is also asking that this motion be denied. It was filed and the filing ID, it was filed yesterday. The filing ID is 86238102.
All right. Next file is that of Lawrence Johnson, case ending in number 1161.
Your Honor, the state is also asking that this motion be denied. It was filed yesterday. The filing ID is 86254763.
All right. Sarah Alicia, case ending in number 1899.
Your Honor, the state is asking that this motion be denied as well. The info was filed on 3/11. Request for administrative transfer filed. Copies provided.
All right, so ordered. Elijah Kraft, case ending in number 16857.
Your Honor, the state is also asking that this motion be denied. It was filed yesterday. Sent to the clerk. The filing ID is 86258948.
All right, so ordered. Molly Fondario.
One moment, Your Honor. I think defense counsel has.
Request from defense, I'm trying to write down the IDs for paperwork purposes back at the office. Could you read the IDs a bit more slowly
All right, that's fine.
for all denials?
All right.
Now, the next case I have is that of Molly Fondario, case ending in number 2001.
Your Honor, the state is asking that this motion be granted. It was sent to the clerk. The filing ID is 86240999. Yeah, that's it for that one.
So I want to make sure I understand. You're requesting the court grant or deny?
Granted, there's a notice of non-filing sent to the
Okay,
clerk.
all right, good enough.
Yeah, that was a mess up, Your Honor. I'm sorry.
All right, Karen Utter, case ending in number 1836.
Your Honor, the state is asking that this motion be granted. There was a notice of non-filing sent to the clerk yesterday. The
All
filing
right.
ID is 862778806.
All right, so ordered. Molly Fondario, case ending in number 2002.
All right, Your Honor, the state is also asking that this motion be granted. There's a notice of non-filing yesterday on
All right.
3/12.
Daquan Walker, case ending in number 2009.
Your Honor, the state is asking that this motion be granted. There was a notice of non-filing yesterday as well.
So ordered. All right, McHenry Francois, case ending number 1973.
Your Honor, the state is asking that this motion be denied. Yesterday, there was a request for administrative transfer filed.
All right, so ordered. Rachel Brown, case ending in number 18004.
Your Honor, the state is asking that this motion be denied. This case was filed yesterday. The filing ID is 862729991.
All right. Brandon? All right. Now, we're going to take a recess. How long does the public defender request?
All my cases have already been completed. I don't believe there's anything complicated coming up. 35 minutes, if possible, for staff to prepare our clients.
35 minutes?
Yes, Your Honor.
All right. 35 minutes it is by my watch. That would be 20 after 11. But,
Let's make it 11:30, please.
all right, Madam Clerk, she wants to make it 11:30, so 11:30 it will be.
Thank you, Your Honor.
Court's in recess till then. Yeah. All right, if council would please announce their names for the record.
Barrington Irvin, on behalf of the state of Florida.
Fernando Perez, on behalf of the Office of the Public Defender.
All right. Thank you. Now, all right, your name, please?
Tasharia Adderley.
Ms. Adderley, you've got a charge here of obtaining controlled substance by forgery. Your bond at this time is $1,000. Now, do you want me to appoint a lawyer for you?
Yes.
All right, Office of the Public Defender is hereby appointed, and that is Division 11.
Your Honor, if the defense may be heard before proceeding, my client, Ms. Adderley, has nothing in the way of a track record. Would it be possible to reduce her bond at this time?
All right, let me review this again. The state have any position in regard to that?
Your Honor, the state will leave it to your discretion.
All right, in regard to this, according to the arrest affidavit, this is one of a number of similar events. So the court feels it would be appropriate to leave the bond as was announced. All right, your name, sir?
Alvarez Perez.
All right, sir, you've got a capias here for a set of charges, failure to appear, no bond, and 2 other failures to appear, no bond. So the judge on that case entered that order. Now,
PD was previously appointed.
all right, public defender was previously appointed, Division 16. All right, next file is that of Jonathan Black. Is that you, sir?
Yes, Your Honor.
All right, sir, you've got a couple of cases here. Purchase of cocaine, bond 1,000. Possession of cocaine within 1,000 feet of a bus stop, bond 500. Tampering with physical evidence, bond 500. Possession of drug paraphernalia, bond $250. And you have yet a second charge, possession of alprazolam, bond $1,000. Now, sir, do you want me to appoint a lawyer for you?
Please.
All right, sir. In regard to the first set of allegations, cocaine, et cetera, that's Division 11. And alprazolam is Division 16.
Okay.
All right, sir.
Thank you.
Good luck, sir. Call that number when you can.
All right, Horatio Brock.
It's Orisha Brooks.
There was a typo, Your Honor.
It was messed up.
All right. I did not understand what the individual said. What is your name?
My name is Orisha Brooks.
Okay, Brooke. All right, ma'am, you've got a charge here, attempted aggravated battery with a deadly weapon. And in regard to this charge, do you want me to appoint a lawyer to represent you?
Yes.
All right, the Office of the Public Defender is hereby appointed. That's Division 12.
Yes. Good luck, ma'am. Yes, sort of.
All right, the next file is that of Cosby Daniels. Is that you, sir?
Yes, sir.
All right, sir. You've got a set of new charges here. Count 1, possession of firearm by convicted felon. Count 2, possession of ammunition by convicted felon. The first count is $4,000 bond. Second is $150. Possession of oxycodone, bond $150. Possession of alprazolam, bond $150. Possession of tetracannabinoids or something like that, bond $150. Possession of cannabis, bond $100. Possession of paraphernalia, bond $100. Now, in regard to this new case here, do you want me to appoint a lawyer for you, sir?
Yes, sir.
All right, the Office of the Public Defender is hereby appointed. Need to look at one other thing here. All right, now, you're out on bond on possession of firearm by a convicted felon, et cetera. And that bond, because of the new charges, is hereby revoked. And public defender is appointed, as I say. And Division 17. All right, Esteban Duran,
Yes, sir.
is that you, sir?
Yes, sir.
All right, sir. There's several charges here. Trafficking in fentanyl, 4 grams or more, bond $250,000. Possession of ammunition by a convicted felon, there's 3 counts of that, bond $150 each. Possession of controlled substance with intent to sell, bond $150. Resisting an officer without violence, bond $100. And possession of paraphernalia, bond $100. Now, in regard to these allegations, I don't see that you've filed the application for criminal indigent status. Can the Office of the Public Defender advise me as to whether you've got present or former representation?
Your Honor, I did not see if he was being represented by the public defender at this time, and certainly not on these immediate charges.
All right. Well, I'm still looking through all this paperwork for one. No, there is none. That's Division 22, and upon application for appointment of counsel and qualification, a lawyer can be appointed. All right, Candy Glenn.
Oh, apologies, Your Honor. If I may, it appears that Mr. Duran has been incarcerated 3 years prior and is now currently unemployed. He should certainly have indigency status. All right. Actually, I'm sorry. Apologies, Your Honor. Okay, so you're gonna have to apply for a public defender's office.
I'm out on a private attorney.
Okay, so you're gonna hire private?
Yes, sir.
Okay, so disregard that phone number and just these are your bonds you have to worry about. I wanna wish you good luck. Don't talk that. Oh, wait, actually, hold on. Don't take that. Don't talk that one.
Your Honor, wait, what was the division on that case? It was a public defender appointed?
No, public defender was appointed. He plans on hiring a private.
All right, and it was sent to division?
I did not hear the division.
Your Honor, Duran Esteban Jesus, what division was that case sent to?
22.
22, thank you.
All right, that's it for the moment. Candy Glenn. Is that you, ma'am?
Yes.
All right, ma'am, you've got a new set of charges here. Possession of cocaine, bond $1,000. Possession of methamphetamine or methylene, bond $150. Possession of cannabis, bond $100. And you are released on bond at this time, and that bond would be stayed. And You want me to appoint a lawyer, correct?
Yes.
Office of the Public Defender is appointed, and this new case is Division 11.
Your last one was still good, so you told me about the bonds. This one? It's tape, it's good. So you don't have any, that's not horrible, we're going over it this time. Yes, the beer side. So you can't bond out yet, so yeah. Card, so you can't bond out till the other county picks it up.
So, when I can't burn out till the other county pick me up?
Okay, so.
Could I burn out now and then the other county pick me up? I gotta burn out first before the county pick me up?
You have a hold for Lake County.
Yeah, that's what I'm saying.
All right, so if they have bonds set up for you on those charges, then you can bond out those.
So how would I know that?
I think it would be provided to you. Hold on. Apologies, records. My client apparently has a hold for Lake County. Would she be made aware of any bonds that Lake County Division posted for her? Okay, you'll be made aware as this goes on. Bond number is in. Okay, all right. You can't, all right, in that case, then you put a zero. Okay, you can't bond out yet. Don't worry about the bond that we're posting out because you can't bond out just yet. All right? Yes.
Next file is that of Sandra Gonzalez. Is that you, ma'am?
Yes, ma'am.
All right, you have two allegations here. Possession of cocaine, bond $1,000. Possession of paraphernalia, bond $100. Do you want me to appoint a lawyer for you?
Yes, sir.
The Office of the Public Defender is appointed, Division 14. All right, next file is that of Hakeem Henry. All right. All right, Joe Huerta.
Yes, sir.
All right, sir, you've got a set of charges here. Trespass on property after warning, bond $100. Possession of methamphetamine, bond $1,000. Do you want me to appoint a lawyer for you, sir?
Yes, sir.
Public Defenders appointed, Division 14. All right, next file is that of Lano Jean.
Right, you have the bonds for this. Again, don't put those two, and put the bond out. Double check on that. I want to wish you good luck.
Your name, sir?
Lano Jean.
All right, so you've got a charge here, burglary of a conveyance, bond $3,500. Do you want me to appoint a lawyer for you, sir?
Yes, sir, because I
All right.
have no one to
Office
bond.
of the Public Defender, Division 14 is appointed. All right, next file is that of Jose Maderos.
Get in touch with the bondsman, they may have good numbers for you.
Your name, sir?
Jose Madero, sir.
All right, sir. You've got a set of charges here. Driving while licensed suspended with 2 prior convictions, bond $2,500. And the other case is involving possession of drug paraphernalia, bond $500. You have completed the application for criminal indigent status. You do not qualify for appointment of the Office of the Public Defender Attorney at this time. You do have, let's see, Division 15 and CRA. All right, is that it? All right, the next case is that of Stephen Steen.
Yes.
All right, sir, a charge here of violation of probation, and there's a conflict in the pleadings here, or the paperwork. You've got 0 bond on the face sheet, and where the judge signed the warrant has a bond of $5,000. So it appears that a $5,000 bond is indicated and has been ordered. Now, sir, there's no application for public defender, so that is Division 22. The public defender is not appointed because there is no request for one. All right, the next file is that of Daniel Vasquez. Your name, sir?
Daniel Vasquez.
All right, sir. You've got a new case involving possession of cocaine, bond $1,000. Possession of paraphernalia, bond $100. You are out on bond on identical charges. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defender's appointed. Now, the bond on which you were released is hereby revoked. Next case is that of Jade Childs. Is that you, ma'am?
Yes.
All right, Ms. Childs, you've got a case here involving a charge of driving under the influence. And do you want me to appoint a lawyer for you?
Yes, please.
All right. Office of the Public Defender is appointed. That's Division A.
Your Honor, my client apparently qualifies for PTR in the revised sheets. She has no priors at all. Would such a action be possible at this time?
All right, so, all right, PTR, be allowed. Cyril Ferguson. Sir, you've got a case here involving a charge of driving while license suspended or revoked. Do you want me to appoint a lawyer for you?
Yes, sir.
All right, the Office of the Public Defender is hereby appointed, Division A, and the bond, if I didn't previously announce it, is $500. Oh, he does? All right, I'm advised that we have yet another case, a probation violation out of Alachua County on which there is no bond. All right.
Apologies, so it was 500 on the traffic and no bond on the VOP, right?
Yes.
Thank you. All right, we can't bond out just yet because we have that violation of probation. So call us when you wish you good luck.
All right, next case is that of Kevin Acosta.
Yes, sir.
Is that you, sir? All right. Sir, two cases, it looks like. A charge of petty theft on which your bond is $250, and then an Osceola County case for a violation of probation, so you have to answer that in Osceola County. Now, your bond on this new case is $250, and in this new case, do you want me to appoint a lawyer from the public defender?
Yes, sir.
All right, public defender is appointed, and that's CRA, it says. All right, Quantavia Jackson. Your name?
Quantavia Jackson.
All right, ma'am, you've got two charges here, trespass in a dwelling. The bond is $500 as to each one. Do you want me to appoint a lawyer for you?
Yes.
All right, public defender is appointed, says here, Division CRA.
Your Honor, if the defense may be heard on this matter, I'm concerned over a possible clerical error. My client allegedly trespassed in one dwelling before being apprehended. Yet I see two charges here for the exact same bond amount. I'm concerned that there was as I said, I'm concerned there was an error in the filing of the charges by officers on the scene. I don't think that's. Let me see.
All right, input from the state.
One moment, Your Honor. Yes, sir. I believe the that is an error. It should be one count of trespass in a dwelling. I do not, based on reading the arrest report, I do not see why two
All right,
counts were charged.
no probable cause as to count 2, then we'll say for the record, and public defender still appointed, and CRA.
Before proceeding further, Your Honor, I would like to ask, since we're down to one charge, if the state had an offer for my client, because we are on a misdemeanor pleadable.
No, Your Honor, the state does not have an offer.
If I may inquire as to records, I had additional notes for my client not qualifying for PTR. Is that still the case, or?
Yes.
Okay. Right, one moment. It is 500 at this time. One moment. Okay, that's our number cost on the can, that's the bond we're dealing with. Can you help with that? Maybe a bond's can help, but I can't say for certain. All right, I want to wish you good luck.
Thank you.
All right, next file I have is that of Kelvin Mobley. Is that you, sir?
Yes, sir.
All right, sir, you've got a charge of loitering or prowling. Your bond on that case is $250 at this time. Do you want me to appoint a lawyer for you, sir?
Yes.
Public defender is appointed, Division CRA.
Apologies. If I may inquire as to the state, Mr. Mobley was only charged with loitering or prowling, and he doesn't, I have not been provided any history on Mr. Mobley. Does the state have an offer of a plea deal, or?
No, the state does not have an offer.
Very well then. Okay, so at the moment, we don't.
Judge, he has an out on bond case. He's out on bond on the case.
Oh.
What's case number?
Are we talking about my client or the next man?
It's 2017 CF 009346.
And you have the name of the charge?
It's possession of cocaine and tampering with physical evidence.
All right. That being the situation on this loitering case, the bond would be increased to $750 from $250 on the new case.
Are you gonna take any action on the other case?
No.
No, state.
Sorry.
All right, the next file is that of Daniel Penaloza. Is that you, sir?
Yes, my name is.
All right. Mr. Penaloza, you've got a charge of possession of drug paraphernalia, bond $500. Do you want me to appoint a lawyer for you, sir?
Yes, please.
All right. Public defender is appointed. That's CRA.
Your Honor, my client qualifies for PTR, and he's been assessed as a below-average risk. Would it be possible to put him on PTR at this time?
If he qualifies for PTR, the same would be allowed and granted. All right, next file is that of Antoine Tyson. Sir, you've got 2 counts here, 2 charges of trespass in a dwelling. Bonds are $500 each, and the total is $1,000, of course. And do you want a lawyer appointed, sir?
Yes.
Public defender appointed, CRA.
Your Honor, if I may, this seems to be the exact same issue we had prior. In fact, it even involved the exact same incident. As before, the police officer seemed to have put 2 charges on the same charge. Could we have I would therefore have a PC challenge to the second trespass dwelling issue.
All right. Count 2, no PC, and the total bond is $500.
Sir? That's fine right now. Call us when
All right, Cameron Johnson. Is that you, sir?
Yes, sir.
All right, Mr. Johnson. Sir, you've got a set of charges out of Polk County, bond $1,000, and in addition, bond $500 for a total of $1,500. And let me check these here.
Is this cadet Carter?
Hmm.
What's his name? Johnson and Barbara Ann?
Cameron.
Cameron Johnson.
All right, the attachment here provides that we have an active warrant for false imprisonment, bond $1,000, and a battery bond $500, and that's out of Polk County. So the total is the original amount, $1,500. All right, next file is that of Sean Safford.
Yes, sir. Yes, sir.
All right, sir, you've got, looks like a 2-count warrant out of Gadsden County. All right, for a violation of probation. So you'll be transported there to answer those charges, sir. All right, next file is that of Carleen Cadet.
Yes.
Just a moment.
The state has an offer for this case, Your Honor.
All right.
The offer is adjudication of guilt 3 days and no return to the location.
All right, ma'am, the public defender's appointed. What says counsel?
A moment to confer with my client.
All right. What the court costs on it?
And I didn't go on the property or in my apartment.
Wait, ma'am. State, in light, Mr. Barrington, in light of the fact that my client has no substantial priors, or any priors it appears, would a possible credit time served be, would be possible?
She has, history.
Huh. All right, hold on. Am I looking at the right sheet? Let's see here. I have,
It was updated.
oh, so this is
Yeah, she
income.
has 1 felony, 3 misdemeanors.
Okay, so she has history. That's very well.
County, and it's open.
The state is not willing to go lower than 3 days.
Okay.
All right.
That's the offer.
He called me when I was walking with my boyfriend. We're
Wait.
both
Wait.
disabled. We're both disabled. He's out there on my mom's phone. I leave today. When we on the site fence. Mr. Jack. Does that make sense? To burn out, state?
Okay, wait, ma'am, please,
Do
ma'am, please,
anything.
ma'am, please, okay. Right. Your Honor, I apologize for the disruption. I would like to ask on behalf of my client if it would be possible to plead to the bench for a possible credit time served adjudication with no return to the scene and, of course, court costs. If not, then my client will have to choose between either the state's offer or fighting this further on.
It's my understanding, in my notes at least, I have adjudication, 1 day, credit for 1 day time served, no return, $273 in court costs payable in a year. What?
The state offer was 3 days.
3 days? Okay, my mistake then. 3 days credit for 1. So, response?
Yes, Your Honor. In light of the fact that the trespass itself was relatively benign, and while my client seems to have priors, now that I've been informed, they are not recent. I do not believe she is a flight risk, certainly. Would it be possible to consider a credit time served if a plea to the bench were submitted?
Let me look here. All right, in regard to this, upon the entry of a guilty or no contest plea, the court would adjudicate guilty, and under the facts here, sentenced to 2 days credit for one, no return, and $273 court costs.
I still gotta pay the court cost, that was.
Okay. All right. The next case then would be Barbara Johnson.
What's she gonna do? Wait, did she accept the deal or?
Just moved on to the next case.
Okay. Okay.
All right, your name, please?
Barbara Johnson.
Ms. Johnson, you've got an open container with alcoholic beverages in it, and let's see, your bond is $250. You're entitled to appointment of a lawyer. You want a lawyer appointed.
He's asking if you want a public defender.
Yes.
Public defender appointed, Division A, offer from the state.
Adjudication, credit time served. And this is for Ms. Barbara Johnson.
273.
You get out of there.
Why they finally changed the clock? All right, so ma'am, you understand, by entering this plea, you're giving up your right to a trial.
Yes, sir.
All right, then the plea's accepted. There's a factual basis here. Adjudication of guilt. 2 days, credit for 2 days, time served. $273 court costs payable within 1 year.
Billy Robinson refused.
Say again?
Robinson refused, Billy Robinson.
Could we have Mr. Robinson reset for, yes, but could we have him reset for tomorrow?
What?
Yes. Billy Robinson. Who do you have?
I got Billy Robinson and Kiara Thomas.
Kiara Thomas. Bishop Bond. Judge, what's the booking number for Kiara Thomas? 7618, 1900-7618.
Here, Tom?
Yeah,
She bonded.
she bonded.
Okay, good for her.
And Billy Robinson.
All right, Billy Robinson was brought in yesterday, looks like, but was mental health at that point.
Refusal.
He refused today.
Refused? Well,
Want
whatever.
to reset one more time?
All right, well, try again one more time.
Thank you, Your Honor.
All right, if there's nothing further, then that would conclude this afternoon's docket. Are there any objections to that? No. Madam Clerk doesn't object.
These two documents, they missed Carly in there. We did that one, but you didn't take these.
Bond thing? Okay.
All right.
Okay. All right, Bondi.
Bond Court is a free service, but it takes several hours of my time every day. Less than 10% of Bond Court viewers hit the like button, and less than 1% leave a comment. If you want Bond Court to continue to be available on YouTube for free, then please hit the like button and leave a comment on all of my videos.